I'd like to introduce myself. I'm Fabian Felix. I'm a PhD candidate at Bucerius Law School in Hamburg, and currently also a Rechtsreferendar at the Oberlandesgericht in Hamburg. So in sometime next year, hopefully, I will have my exams and I'll be a lawyer. So right now, I'm just a student and researcher. Felix, would you like to say a couple of words?
Yes, of course. I mean, first of all, I think it's going to be more relaxed than Martin hinted at with the schedule, but at least we are trying. But yeah, no, I'm Felix. I'm also a researcher and PhD student at Bucerius. Actually, Fabian and I work at the same center, or yeah, the IP center at Bucerius. And yeah, that's basically it. So yeah, our paths crossed that way around to the open source hardware issues, and actually we're working on that on a day-to-day basis, I would say, in the last year at least, and completing the guideline and starting research, because as Martin pointed out, it's basically so that the law is not construed in a way that's, at least from the point of view of being the original target of what should be the open source hardware issues, or open source issues are not the focal point of copyright or trademark or patent law. So we need to figure ways out in which we can incorporate those ideas and principles and make use of the law as it is at the moment to yeah, achieve our goals actually of being open and distributing and so on. Yeah.
So I would suggest that we dive right in. Of course, we have a presentation prepared. Yeah, Martin?
I just noted that I hit record after my intro, so I would like to use like 2 sentences or so to introduce myself, why I am here, and then yeah, okay, so I come from the open source hardware community. I'm chairman of a small research organization that acts as a legal vehicle for open source hardware projects in Germany, now also Europe. And when I started a couple of years ago to dive into the concept and the community and the projects, I never thought that I would ever be interested in legal issues, because up to this point, I tried to avoid them as far as possible. I never talked about licenses or contracts or all of these things, but they are inherently necessary, since open source is, for me, sort of a workaround around the IP law. Things are not open source by default, so we need to make them open. And so a basic knowledge is required. And then when touching all these other issues that may occur when I do something open source and everybody can use it, and people may sue me for something that I published 10 years ago, so then I indeed got interested in how that all works. Yeah, that's how the group came together. Now back to Fabian. Thank you.
Yeah, all right. So I'll just share my screen for you so that you can see our presentation. So can you all see the presentation right now?
Yep.
Great. So what we are going to do today, by the way, in the background, that's the Bucerius Law School in Hamburg, in case you were wondering. So that's where Felix and I work on inter alia open source hardware issues on a daily basis. What we are going to do with you is an introduction into the legal aspects, because when we talked with Martin in preparing this workshop, we had the impression that, like Martin just said, you maybe didn't have so many contact with legal issues until now, or have some questions you want to ask us. So we were first, we are going to give you a brief overview over what what we are talking about when we're talking about open source hardware from a legal perspective, and a little overview about our research in Hamburg. And then we are going to dive into selected topics which we think might be most interesting for you, and which are all related to IP aspects. So we are going to talk about intellectual property mostly today, and not about, for example, liability or damages, etc. So this is the program we have in mind. First, as I said, our definition about open source hardware, because in all of the time I have worked on open source hardware, I found that it's really important that we as lawyers, when we're talking with the community, with people like you, it's really important that we understand each other. And just yesterday, I noticed that sometimes Martin and I use different definitions for certain words. So please don't hesitate if you have a question, if you don't understand anything, to raise this issue right now. Then I'm going to give you a little teaser on what's currently going on in Hamburg, in particular the FabCity research group that we have here, and which just really started. Then we have three main topics today. The first is the legal material. So what rights are we dealing with? What IP rights when we're talking about open source hardware? How can we manage these rights? And what can we do to defend open source hardware, so to make sure open source hardware stays open? And then we have room for discussion. Since we have a couple of hours, we will take breaks between the topics, and we have a little room for discussion at the end of each topic. So if you have any questions or concerns, anything you don't understand, then you can raise this at the end of each topic. And in the end, I think we will also discuss about how to proceed, because I think it was also advertised this way. We can offer to have more workshops on this for specific topics, and we really want to tell you what you want to know, what you need to know, not what we think is best. That is part of it, but we really want to do it the way that it's a service for you, basically. So what are we talking about when we talk about open source hardware? I broke down the open source hardware definition of OSH and mentioned into the aspects that are most relevant for our legal work, I think. So the first is open source hardware concerns tangible artifacts. So it's not code, it's not software. This is what makes it harder and more difficult, because, as you know, or may already think, a whole open source hardware project can also be firmware or software parts. So there may be hardware and software, but open source hardware per se is only tangible artifacts. Then it also concerns a design that is released to the public. So private use is not so great a concern for open source hardware from our point of view. And of course, open source hardware needs to be available in a way that you can make free modifications and that you can freely use it. And another very important point is free redistribution. So it's not non-commercial. You can redistribute open source hardware commercially, but that's a point I will get to later when we talk about licenses and how to manage the rights. Another important aspect that frequently led to litigation is that you have to give attribution to the ones who developed the open source hardware initially. I have two case examples later on which concern open source software, but which are good case examples because the principle is the same. In fact, the open source hardware definition is based on the definition for free and open source software. So the cases are comparable and can give you an overview of what could happen if you don't give attribution. Some upsides and downsides for open source hardware. One is a point we might have to discuss because Martin is of a different view in that. First, the upsides. Open source hardware has a great potential for crowdsourcing ideas, for taking really the minds of a lot of people to solve important problems. And nearly all of the open source hardware projects I have seen so far are really interesting and partly concern problems like how to clean water, make it available for everybody. So there's a lot of potential there. And because you have to make it available for people, it has a great potential for making knowledge in general accessible. It's a little like the intention of the patent system that you have to make your patent available so that people know what it is, but people can use it. So it has you know, in a patent, you're generally not allowed to use what's patented as long as it's patented. So it has a great possibility for making a lot of knowledge accessible in a way that people really can use it. And the downsides, and this is something we might have to discuss, is I think if done properly, you have to make an effort to manage the existing open source hardware rights. So to choose the license you want to have, the right license, to control the downstream use of open source hardware, for example. Then you also have the litigation risk, and what we are going to talk about today mostly, I think, is new legal challenges, and at the same time a lack of support. So you have a new legal challenge, you have something that's never done before, but you don't know how the law works. Maybe from policy kind of view, the law doesn't work right for open source hardware, so maybe makes it impossible or hard to do. So these are some of the downsides of it. Then to give you a quick overview of what's going on in Hamburg right now, what we are doing, we have a consortium of 5 members here in Hamburg who are all doing research in open source hardware. Bucerius Law School is doing the legal aspects of open source hardware, so the legal research. The whole project is anchored at Helmut Schmidt University. There they are doing research on value creation systems, circular economy in general, and bottom-up economy, for example. Then we have the FabCity Universität, the HCU, which is concerned more has a more macro view on things. So they are thinking about how to plan a city. What do you need? How do data and goods flow to enable open source hardware in a city-wide view? Then we have the Kühne Logistics University. They are taking care of research in supply chain management, digital economy, and 3D printing in general. For example, they are doing research on why 3D printing sometimes doesn't work or doesn't give proper results. Then we have the TU Hamburg, which is a more technical university and does research on user innovation and in particular innovation diffusion. So what are diffusion barriers? Like are projects easy to use and to rebuild, or are people afraid of litigation and being liable for damages, etc.? And they are also doing research on DLTs and NFTs. What we do with our legal research at the moment is we are looking at decentralized digital production for urban value creation, and our legal topics are to establish practical guides for open source hardware for Fab Labs. So it's similar to what we did, what Martin already mentioned, to the guideline we have online, but the guideline is more general and gives more of an overview of our open source hardware, while these guidelines are targeted at Fab Labs, so people who are Fab Lab managers or working in Fab Labs and what they have to observe in the Fab Lab environment. Then we are looking at IP rights in the circular economy, for example, the right to repair, at open source hardware licensing schemes, and at technology-sensitive liability law. So, for example, if you're interested, I'm sure that we can find a way that one other researcher from our group who is taking care of the liability law can make another workshop with you, for example, and explain you the basics of liability law if that's interesting for you. So that's enough from my part for the moment to give you an overview of what for us, what is open source hardware, and what are the what are we doing right now in Hamburg. So if you don't have any questions right now, I would hand over to Felix. Okay, I don't see any questions. Yeah, I don't see any questions, so just go ahead.
Okay, yeah, so the first part of the more legal aspects of this workshop are about, I mean, definitions are one part of what we need to establish before we can talk about how licenses work and how we might deal with certain liabilities from IP rights. But in order to understand how those licenses are structured and what matters most to an open source project, or an open source hardware project in this case, we need to talk about what relevant IP rights are there, how do they function, and what parts of a project we can protect with them. And yeah, so let's start with that actually. So why are we actually talking about IP rights? I mean, everybody heard about a copyright infringement, for example, when one software firm is suing another software firm for some sort of infringement of a source code, for example, of the software. But is that all relevant to our projects because they are hardware-based, for example? And in order to understand what is relevant, actually, we need to take a look at how those IP rights are structured generally. So we are seeking a sort of free and open source product development. So we can redistribute, we can make available those innovations to others and give them a chance to collaborate with us on this idea, on this technical product, and make it into a better version, for example. And usually, this is not the, yeah, thanks. Usually, that's actually not the target or the main reason why IP rights exist and what they are used for. Usually, IP rights are there to protect against others in using our innovation, our product, our work in the broadest sense. And we want to use an IP right to protect it and say, no, you can't use that. So third-party exclusion actually is the main driver for IP rights and how they are structured. But this is actually not what we want to achieve. So we need to find a way in order to utilize those exclusionary IP rights in order to make it inclusive for others, in order to make it available to others. But we need to keep in mind that this default mode of IP rights of being able to exclude others from using what is protected is also the reason why we need to be careful at some points that malicious third-party actors don't come in, protect something, or have an established right and try to protect, try to exclude us ourselves from being able to make our innovation, our open innovation available to others and harm us and the open source idea in that sense. And we can do that actually. So the good part is we can do that, and there are strategies to do that. And let's now move on and see how that can actually happen. So the next slide would be, yeah, thank you. So this is how a non-open source company would use IP. So there are maybe patents, there are certain trademarks. I think of Microsoft, for example. So they have patents for certain software and certain hardware. and they have trademarks for their logo and for certain brand names. And then they have copyright on certain source code, for example, and maybe some other rights like design rights or utility models and so on. And then they structure it in a way and hold those IP rights and try to establish a boundary for others. So they can't use what's inside this non-open source company veil or protected a bubble of IP rights. And yeah, let's move on. So this is basically it. So non-open source company, they're trying to stop use of similar technology. So they try to stop you from using their documents they acquired, from using certain trade secrets, for example, they gathered from certain knowledge they gathered by protecting it through acquired IP. Yes, but we, as an example, are trying to do something different. So the next slide would be great. Thank you. We are, in a sense, an open source company or an open source inventor. It's only one person. And we are trying to use those similar IP rights. So we are not actually using something different. So we are still using patents. We still use trademarks or copyrights, or we can use them at least, and try to use those same IP rights, but in a very different way, actually. So the next slide, I think, illustrates that way. So we use those IP rights that also Microsoft or other for-profit companies are using, and we try to encourage the use of what we protected with those IP rights and try to encourage others to improve upon our technology and try to get the ball rolling on having better iterations of our work. And we can do that, but we also need to acquire certain IP rights, or we at least need to be aware of how those IP rights are acquired by others or by us. And we also need to be aware of how they work so that we can create a bubble of IP rights that are targeted at making improvements through open source. And that's actually the main point why at some point, or from time to time at least, some companies or some inventors struggle with IP rights. That is, that there are malicious, they don't need to be malicious actually. Sometimes there are certain innovations that are similar to other innovations that are made by a for-profit company, and they feel that they need to protect their market space, for example, and then they try to block you from getting into the market space through IP rights. And so we need to be aware of that so that we are not the target, or at least we have good arguments in our favor to make that risk a bit more manageable to us. So in essence, which IP rights do we need, which are relevant to us? And there are two questions, I think, that are most important for that. We need to, first of all, not on a legal level, but on a practical level, we need to figure out what is most crucial to our product. We need to figure out which parts of this product are most crucial and to our success and to our being able to distribute our innovation successfully. We need to figure that out first, and we need to figure out which are so crucial that we want to protect them, and we need to protect them to move on in the future. And if and when we determine this, for example, we have a certain circuitry board, for example, that we develop that is unique in a way, and we need that for our special kind of machine, otherwise it won't function. And we believe that this circuitry is so important to us that it needs to be protected. If the circuitry, we are prohibited from using that circuitry that we invented, that we build ourselves, or that we want to make available open source for others, that it's so important that if another party comes in and says, no, you can't use that specific circuitry board, then we are basically doomed. So if that happens, that is so important. That would be an example of what we need to protect. And then on a second level, we can say, okay, the circuitry board, how are we going to do this actually? How are we going about protecting this with IP rights? And then we'll find our intellectual property right that is best suited for this example. And that's what we are going to do next. So we are going to take a look at different parts of a product. For example, we are going to take a look at software code, at hardware, but also at other intangible goods that are not hardware or software related, for example, logo or our company name or certain packaging design that we want to establish, or that is associated with our brand, for example, with our machine that we want to package in a certain way. And the blueprints, for example, are needed, and other parts of our product. And then we are going to evaluate which IP rights are best suited for that.
If I may add,
Yeah.
just briefly, what you said before, we have to decide what to protect. I think Arduino is a good example because they have a well-known trademark. So one strategy may be that you don't have to protect a circuit board or a motor, etc., with a patent or something like it, but you can have a well-known mark established. You have to put some effort into that, but then people buy the quality you assure instead of something everybody can build and you don't know what quality it has. So this is one example for different strategy than going for full IP protection for a certain element.
Yeah, great example. I mean, in essence, so having an open source project doesn't mean that it has to be non-commercial, for example. So there might be parts that you want to establish that generate a certain amount of revenue and that you want to protect at all costs. And then there are other parts which are non-commercial to some extent. You don't want to generate revenue. It's just for the community of having this collaborative effect of having new inventions that are built upon this. And we try to, or at least it's possible, to make both routes available and make both routes both legally and commercially viable and to coexist. Yeah, Martin, yeah.
Yeah, just a comment on that. to be clear about what we're talking about. So non-commercial is not open source. So I think all you want to say is that you can perfectly mix proprietary and open source modules. That is done in software, for example, when you have a premium version of your software, especially online, and then those features are, of course, not freely available. That's called the open core model that also exists in hardware. And yeah, you can do the same for yeah, exactly as for hardware. Yeah, I'm not aware of any project that uses specifically modules that are prohibited for commercial use and the rest is open source. But yeah, just wanted to make this clear.
Yeah, thank you. So it's all possible, and we can mix and match actually. And yeah, so let's take a look at which IP rights suit those intended protections actually. On an abstract level, there are certain categories, or at least rule of thumbs, by which you can differentiate between certain IP rights and what they should be able to protect. So one category, one of four we identified, are ideas versus expressions. And what that comes down to is that if you have a certain idea of a technological invention, for example, a certain mechanism that functions in a way, or a certain blueprint of a machine that you want to protect, but that is not actually built out, for example. So you don't want to protect the model that is physically available, but you also want to protect certain functions of that machine. so ideas in a sense, but not expressed ideas, then you might want to consider patents, for example. Patents are well suited for those sort of more into the realm of ideas that you want to protect. And on the other hand, if you want to protect, for example, an example for that would be source code. If you write source code for something, or you write a detailed documentation for something, that might be most relevant. So if you have documentation for a certain product, for a certain open source product, then that's an expression. It's not the idea of a documentation, but it's what you've written down in a guideline, for example, in a certain documentation document. And that's most relevant for copyright protection, because copyright is not concerned with intangible ideas of a product or of an artistic work or of a documentation. It's concerned with the concrete expression of this idea. And on another level, there are certain rights that are geared towards technical inventions and technical products. So, for example, if you have a the certain machine, for example, you might be or the IP right that could be most well suited for that are patents, of course, but also utility models. They are geared towards technical inventions. On the other hand, if you have an artistic work, and artistic is here in the broadest sense, it's not a work of art, for example, and nobody needs to produce a work of art to get copyright protection, but it's in a way it needs creative input that is not technical per se. So, for example, a certain illustration of how this machine would work, that could be protected by copyright, the picture of it. And then there's another broad distinction between registered and unregistered IP rights. And registered IP rights always, you need to apply for those IP rights. They do not arise naturally just by you inventing a certain mechanism or a certain machine, and then out of a sudden, without you doing nothing, this IP rights is granted and you have it. That's not the case for those rights. You need to write down what you invented, how it works, how it functions, and then you need to go to your, for example, the patent office, and you need to hand your documentation of that in and what you want to have protected. And then the patent office, for example, might grant you a patent on that, and then it's registered in a publicly visible register, and there you can see all the patents that are available. On the other hand, for example, again, copyright is a right that is that you don't need to apply for. You don't need to go to a certain body like the I don't know, the copyright office. There's nothing. There's no copyright office. You need to go there. If you draw this illustration, or if you write down the documentation for how your machine works, then it's automatically in that moment, if it reaches the threshold for being protected, it is protected. There's no application for it. It just arises naturally. And finally, there's a distinction between national and multinational rights. So, for example, trademarks come in various flavors of how broad their scope of protection around the world is. There are national trademarks, which are only valid in, for example, Germany or in the Netherlands or in the UK. And then there are certain multinational trademarks, like European trademarks. European trademarks are valid in all the countries of the European Union, for example. And we need to figure out along those rule of thumbs which protection we want and what suits our practical element that we want to protect most. So let's take a look, at how this actually works out in detail. And I think we're going to start with patents. So as I mentioned, patents are geared towards technical inventions. So if, Fabian, maybe you can go one slide further and so an open source hardware example would be a certain hardware component, a motherboard, circuitry, or a mechanical component. And now we can go back maybe to the, thank you. So keeping this in mind, that's a very technical invention. It's not, it's not logo. It's not software code written down. It's mechanical, for example. And this is actually what patents are geared towards, and they are only geared towards those inventions. So we cannot protect logos with a patent. We cannot protect. So in Germany, we can not really protect a software code to a certain extent with patents. It is possible in some countries to protect, in the broader sense, software code with patents, but for example, in Europe, it's basically it's not intended to protect software code. So if we think about patents, we can think about mechanical or electrical electroengineering inventions, and we want to protect that. And there are 4 main criteria that need to be present in order to gain patent protection. And that is a certain patentable subject matter, it's called. So as I said, you don't want to protect images, or you don't want to protect certain forbidden patentable subject or non-patentable subject matters. For example, if you have an invention that goes hand in hand with how the human body works, for example. So if you have a certain part of the human body that you altered, that's not possible. You can't protect parts of the human body. And you cannot protect certain military items, for example. So there are certain restrictions as to what you can do. And second level, this invention, this technical invention, needs to be novel. So it needs not to be done before, as patents are usually geared towards protecting novel items, protecting the advancement of knowledge through those inventions. And we don't want to protect something that has already been there. We want to reward the applicant, the inventor that does something new. So it needs to be novel. And it also needs to be useful, which basically means that you must be able to apply it practically, and you need to be able to prove that it really works, it functions. It's not something imaginary that won't work in practice. It needs to function in practice to be protected. And finally, and possibly one of the most important parts, and one of the parts that most likely will prohibit most inventions from being patented or patentable, is an inventive step. So you need to prove that what you have is not only novel and useful and patentable subject matter, but it also goes beyond a certain level of obvious inventions. So if I were to invent a mechanical arm for a machine that has been done in a similar way before, and I'm only iterating closely on this invention that has been done before, that won't be enough to fulfill the inventive step. But if I were to do something new that is non-obvious to somebody that is experienced in the field of engineering, for example, that this applies to, and he says, well, yeah, that's not obvious, that's really something useful and something inventive, then this fulfills the inventive step and I can apply for a patent. And we need to watch out for this inventive step most of the times in order to be able to patent some subject matter. And if we fulfill all those rights, patents are actually granted for a rather long time. So 20 years at maximum. And that is, as there are treaties on how patent rights are structured across the world. That's basically something that you can rely on in most countries of the world. There's 20 years protection and the required steps that you need to fulfill to have something, an invention, patented. And the great advantage of a patent is that it, in essence, it protects the idea behind what you are patenting. So if somebody comes along and he or she is copying your mechanical arm, this inventive new mechanical arm for a machine, but he only alters, there are only slight alterations to that arm. For example, another color, different screws, a certain other way of how this mechanical arm might work in practice. That for some IP rights might be enough to conclude that it's not an infringement of your patent right, but of your, sorry, not patent right, but for example, of copyright or of trademarks and so on, but not for patents. If you say, well, but my idea that I patented is this mechanical arm with this functionality, and basically that's also the functionality that this other mechanical arm uses, then you have good chances of being able to claim that this is some sort of infringement to you. So it's a very broad protection of your idea. And it is a registered right, so you need to apply for at the National Patent and Trademark Office, but there's also, for example, a European patent that you can apply for. So there are multinational and national parts to patents. You just need to choose. Yeah, next slide. Yeah, thank you. And in practice, so do we need to worry about patents if we start on our journey of producing open source hardware goods? And my honest opinion on that is, yeah, probably. So it's a category of better safe than sorry. There are a lot of patents, and patents are usually tailored towards being broad in protection. So they are not tailored towards being very limited in scope. And this broad protection usually makes it difficult to understand at first glance whether my invention is or could be infringing on that or not. And so we usually need experts both in the field of how that works mechanically or from the invention point, practical invention point of view, as well as on the legal side of view, to understand whether there are significant risks. But if there are, then we might walk into the trap of having litigation brought against us. And this litigation in patent suits are usually very costly because we need those experts, both legal and technical, and they drag on, or they tend to drag on, and they can cost a lot of money, and we want to avoid that. And that's why I would say better safe than sorry. So patents usually is something that you should take a look at, and could also be beneficial to talk with experts in your field from a technical perspective, but also with experts on the legal subject matter that are educated, so that you can get a sense of whether certain patents pose a significant risk or not. Obviously, if your invention is very small and it might fly under the radar of certain companies that seek patent protections and enforce their portfolio, but usually we don't want to rely on that. So because even if it flies on the radar, you're still in this bracket of having some risk exposure to others coming in and blocking your use. And how do you get a patent? So if you want to apply for that, you can go to your local patent office, which are usually combined patent and trademark offices. And they have detailed information about how this application process works. And you can also, yeah, basically call a lawyer or ask legal experts about what you need to do, and they will guide you through this process. And what you need to be aware of is that there are two types of lawyers that deal with patents. So first of all, there are lawyers in the classical sense that might do patent litigation and also might structure how a portfolio works and how certain claims work. And then there are so-called patent lawyers, which are usually experts in some sort of natural science. So they have, for example, a degree in biology or a degree in mechanical engineering or electrical engineering or in chemistry. And then they have another additional education in how the law or the patent law system works. And they are usually very skilled in reading those patent claims in the patent application and can help you a lot in how they aid in how you can apply for patents and be successful in applying for it. Yeah, so we also talked, we already talked about the open source hardware examples, but there are many. So anything that you can imagine that is mechanical or that is electronic, that usually is a subject matter that could be patented if it fulfills the other steps. And as we are dealing with hardware products, usually patents are the IP right that we should look at with the most focus and that might be most beneficial to most open source hardware projects. That's it, basically an overview for patents. Any questions at this point? Okay, I don't see any, so I'll move on with utility models. And basically, utility models are something that is not present in all jurisdictions. But for example, in Germany and in some other European jurisdictions, utility models are present and you can use them, and they are basically small patents. So we are still talking about technical invention, and you still want to protect the idea behind your invention and not just the expressed work. And as such, those utility models were created as a way of obtaining patent-like protection, but with fewer hurdles in order to obtain this comparable protection. And utility models are also, you can obtain them in a faster way than patents. You still need to adhere in the end to the same requirements, so patentable subject matter, novelty, usefulness, and the inventive step. But when you apply for a utility model, for example, at the German patent office, then the examiner is not going to examine in detail whether you fulfill each and every step. So those 4 steps: subject matter, novelty, usefulness, and inventive step. He or she is not going to examine in depth whether those requirements are fulfilled by what you are applying for. If you apply for a patent, that's examined in depth, but not for utility models. So it's faster, but it's also less reliable in the end. Because if you end up with somebody who's saying, well, your utility model is not valid because you don't fulfill the requirement of novelty at the time, and he sues you or tries to invalidate your utility model, then this is tested and examined in depth. And if you really don't fulfill that step, you might not have protection even in the past, or you have had not protection in the past. So that is a huge downfall. It's less reliable, but it's faster. And if you're very sure about that you fulfill all those 4 steps, and you're very sure about that you can prove it even in the future, then utility models are a great way. And sometimes you can even utilize utility models in order to have an invention that you don't want to patent yet, but you want to have some sort of protection for it, or for example, an alpha version of something needs to be protected. This is a technical invention. You want to protect certain parts of it. So you can try to get a utility model first. And when you're done with your invention and you have not publicized all of the findings and all of the things that make your invention great, and now you have a better or final version of it, now you want to get patent protection for it, then you can still do that. And so you have a continued basis of protection where you utilized those utility models in the beginning. But in essence, it's a faster way to protect, to obtain patent-like protection. It's also a registered right, so you need to apply for it, but you can also search the database of the patent office. Yeah, a question, of course.
Yeah, can you hear me?
Yeah, I can hear you.
Okay.
Yeah.
You said the utility model and the patent protects you, but in my understanding, you have to ask a lawyer to look after your case and attack another party. Also, you can't, it doesn't protect you. You have to actually attack another party with your patent. How does the patent protects you?
Yeah, so the patent, which goes hand in hand, actually. So this sort of litigation that you're referring to based on a patent or a utility model is using the protection of the patent. So you can exclude others from using similar inventions, for example. That is one sort of one way of how a patent protects you from others infringing. And if you, that's the protection area. But if you want to be able to actually to prohibit the others from doing that, you might need to go to a lawyer to enforce your protection. But the protection itself is always there. So you can prohibit others from using that. But yes, you need to act on it. Yeah.
And I have to look at the market if someone is infringing my patent.
Yeah.
Or does this another person for me?
No, but that's actually another aspect of how you are protected. So yes, if you want to enforce your patent, you need to look at others. For example, what are others applying for? For what patents are others applying for? And they are available on the website, on the register of the trademark office or the patent office. And there you can look up, well, somebody applied in a similar category for similar claims, and their patent is newer than my older patent. So you can take a look at that, and then you can say, oh, they are similar. I want to enforce my protection against this newer patent. I want to invalidate it. But you need to look at what others are doing first. Or you can look at how people are in reality using certain products. And if you spot something that is functioning in a similar way to how your patent claim is, what your patent protects, then you can go along and say, well, I want to prohibit them from using that product in the future because it infringes my patent. So this is what you need. If you want to get active, you need to do that. You need to monitor what patents are applied for, and you need to monitor what others are doing in the marketplace. You don't need to in order for your patent to be valid, but if you want to enforce it, you might want to be on the lookout for what's happening there. But on a more passive protection, so where you don't need to do anything, but you're still getting some protection from your patent, is your patent is registered on this website of the patent office. So if another party is thinking about, for example, applying for a patent that might be similar to yours, they should search for what patents are already existent in the registry, which includes your patent. So they might look up mechanical arm inventions that include some sort of glowing material, and then they type that in, they search for what patents are already there, and they might find your patent, and then they themselves are deterred usually from applying for a similar patent, or are at least aware that you have a patent on that, and they might be also deterred from using that in their product in real life. So that is a sort of passive protection that your patent can get you without you needing to do anything about it. And a third area of where you get patent protection and you can utilize it without attacking others is that you are, due to you being able to prohibit others from using your invention, you are also able to allow others to use your invention in certain ways. So that's where you can go and say, well, I want to license this to other people, for example. And this is only possible if you have protected your invention and you're able to exclude others, then you're also able to allow others. And that does not include going to a lawyer and saying, well, attack this or that person because they are infringing on my rights. But you're able to say, well, I want to allow certain other persons to use it explicitly and maybe get some sort of revenue from that, or being able to participate in an organization that shares those patents with each other. So that could be a third area where patent protection or utility model protection is granted. I hope that, yeah. Any further questions? Okay.
I'd like to add something to that with regard to passive patent protection. A patent can also act as a threat in two ways. So if you have somebody thinking about attacking you, if you have a patent, or better, if you have licensed patents with others and pooled and build a pool of patents, then a third actor, for example, a troll, maybe think twice before attacking you because he sees that you have a lot of patents. So the risk of a failed and a costly patent litigation against you increases with the number of patents you have, basically. And on the other side, if you want people like to keep in line to adhere to open source standards, and if you want to keep third parties who are not open out of your project and on your technology, then it's also a threat without you doing anything, because if they see that you have many patents, then they will maybe think twice before entering into that technology and into that market. And maybe one last point I want to mention, which is very problematic from a practical perspective, is that there are so many patents right now that it's very difficult, and I have seen this regularly in real cases, to assess whether a technology violates a patent, because there's a real patent thicket, it's called, so that you can't really say. And simply the existence of a lot of patents can pose a threat to a malicious actor or somebody who wants to interfere with your open source project.
Yeah, thank you for that. So basically, it can act as a sort of collateral or a deterrence to others. Yeah, very valid point. Thank you. Going back to utility models then, or closing with that actually. So they are registered just like patents, as said before, and they're mostly national rights. Yeah. And let's look at, do I need to worry about that? So we touched upon the, do I need to worry about patents and utility models? Yes and no. As Fabian said, there's a real sea of patents that are registered and applied for. So we have to be on the lookout for whether there are patents that obviously are infringed by our inventions. And we also need to take into consideration that it could be costly if we do not have this sort of evaluation beforehand. But apart from worrying about it, it can also be a great asset to your endeavor of open source hardware products. So patents and utility models usually are a good thing to acquire if you are at a stage in your project that this is a sensible option. And just like patents, the local trademark and patent offices will provide you with further information. And also there you can look up other patents and utility models and whether they are similar to yours or at least in the same neighborhood. And just like patents, so specific hardware components, motherboard, circuitry, the mechanical arm I dragged into this is a good example of what could be protected in the open source context. Okay. My suggestion would be that we briefly touch upon design rights now and maybe do just a short 5-10 minute pause afterwards before we look at trademarks and copyrights, if that's okay with everyone else, because I think we already did now. Okay. Design rights, what is that actually? In a sense, you can try to imagine that patents are protection for the inner workings of your invention. So the idea behind it, how your mechanical arm functions, and I'm not straying away from the mechanical arm example by now. And design rights are about the outer appearance mostly of your product. So if you have something that relies on a certain appearance, a certain aesthetic, then you might be able to obtain design rights for it. So a great example for design rights are not in a mechanical sense, but you could, for example, look at certain, for example, design chairs or certain products that are easily recognizable by how they appear on the outside. And that's what design rights were originally intended towards. So protecting how something appears, but not the inner workings of it. And yeah, that's basically it. And yeah, Martin, yeah.
Yeah, quick question. How are design rights different from copyright? If it's an artistic work, why do I need to register it then?
Yeah, good question. So there's some sort of overlap. So if you produce something in 3D, for example, that is of great artistic craftsmanship, then that also might be protectable by copyright. But and could also be protectable through a design right. But if you acquire a design right, and that is the main difference between copyright and design right protection, if you acquire a design right, your scope of protection of what you can prohibit from others, from using what others might be using, for example, variances in how this appearance is altered from your original product appearance, it's very much broader with design rights. So a copyright, you might, practical example, if you have a, I don't know, it's some sort of Smurf, for example, 3D Smurf in blue, in a certain shade of blue. And now you formed that in your 3D printer, for example, and this Smurf has I don't know, some features that are unique, I would say. And you crafted that, and that could be protected by copyright, even its shape and color, so how it's composed in that moment. But if somebody alters, for example, the color and alters minor details minor to medium details of how this Smurf is composed, it might not fall under copyright protection anymore. Although others, third parties, might still think, well, that's the Smurf Martin did, so it must be a red version of it, so I want to buy that, or that must be associated with yours. But that's not the case for design rights. So it's a very much broader protection of what you can acquire there.
All right,
yeah, so as a rule of thumb, there are also other differences, but I think mostly it comes down to scope of protection. which is basically the case for also for trademarks. You can have a logo that is copyrightable, but if you use trademark protection for it, it's very much broader. And yeah, so that's basically the rule of thumb. So copyright is usually a fallback solution, so that it arises naturally, and you can get copyright protection for so many works of creative works in a sense, but they might not be protected in the broadest sense compared to registered rights, for example. Okay, yeah, great. But good question, thank you. Also design rights, they also have some sort of requirements, so they must be new. So they are the Smurf example, there must not exist a Smurf with a similar shape or a comparable shape, and they must be original. So there should not be something that is too comparable to yours. So that's basically it. So they go some sort of hand in hand, new and original, but it must be different from what is already there in the existing body of forms. Yeah, and then you get a grant of protection, which is at minimum 10 years. And Fabian, please correct me if I'm wrong, but design rights, you can extend them without, I think, conclusion in most jurisdictions, right?
I'm not sure whether this applies to designs. I know it for trademarks to be true.
I think it also replied. Okay, something to be discussed. Yeah, but usually, yeah, trademarks can be extended indefinitely. I think designers can be extended also, but you have a minimum protection of 10 years, which is a, yeah, longer period of time for most products. Registered or unregistered, they are registered, so you need to apply for them. They can be applied for at your trademarks and patent office. Usually they are combined, and you can apply for both a European design right, for example, so a multinational design right, which is if you want to protect your design in more than one jurisdiction, it's usually more cost efficient to go for a European design right. And if you only want to protect in one territory, for example, Germany or the Netherlands, then a national design right might be the right answer to your call. Yeah, so next slide, please. And I can come back to you on the extension conundrum, I think, after the break. I'll look it up and then we'll have a definitive answer. And do I need to worry about design rights? In the context of open source hardware, I would say that design rights could be something that you should check on, but I would say generally design rights are not your major concern, because design rights, as they are only geared towards the appearance of something, are not what I would expect people in the hardware product space are thinking at first glance about. So, and they might not be suitable for all applications. So there should be a limited, a potentially limited risk from design rights in comparison to, for example, patents or copyright for certain codes regarding software, for example. But as with all other IP rights, if you are infringing upon a design right, and it's rather easy to check, so it might be worth checking for that, then the litigation that ensues, or usually ensues, is could be cost intensive and could hinder how you can market your product and distribute your product. So also better safe than sorry, but in comparison to patents, I would say it's a lesser risk, or potentially a lesser risk, at least for most projects. If you heavily rely on certain, on the appearance of certain parts of your product, on the overall product, then you should obviously check for it. But if it's more on the mechanical, technical invention side, design rights might not be your major concern. But it's on a case-by-case basis. So obviously better safe than sorry. How do you apply for it? Just as with the patents and with the utility models, your local TMO, or the TMO, by the way, is Trademark Office. So your local office will provide usually detailed information about that process. And also the European, it's called the EU IPO. So the European Intellectual Property Office can also provide you with more details on how that works, but it's usually a more straightforward process and can be done. And examples for how that would work, I've given a few in the last 5 to 10 minutes, but when you have a mechanical component that has a certain specific 3D appearance, you can think about protecting with additionally with IP, with design rights. And yeah, but keep in mind, it's not about the functionality. It's only about the appearance and the outward structure of your product, not the inward structure. And that's basically it for a design. Are there any questions on design rights, additional ones? No. Okay. Then I think a quick 10-minute break.
Welcome back. And Leopold has a question, I think.
Ah, yeah.
Yeah, the question is related to patents.
Mm-hmm.
There is a homepage and the idea of an open patent office. I put the link into the chat. The homepage exists since some years without any visible progress, but I would like to know what you think about this idea. Would this be a possibility for defense publication, and is it possible anyway to call it open patent office?
I just took a brief look at the link you sent. I think it's a possibility for defensive publishing, and I think there are similar projects that do exactly the same thing, so that you can. I will talk about this a little more in detail later, where you publish your invention to destroy novelty, basically. However, maybe the reason why there hasn't been any progress is I think it's a little misleading, because when you call it open patent office, you're hinting at protection similar to a patent, which defensive publishing is definitely not. So maybe that's the reason that maybe people are disappointed, because they expect different things than they get from this. That could be a reason from my point of view.
Yeah, possibly. I think actually, Fabian, if you knew something, or anybody else knows something more, but could be interesting to have a register of patents that are either licensed through certain licenses that are at least targeted to be open, or that are part of certain, for example, patent pools, which would be more in the spirit of open patent office, because that would still be patents, but they are used or pledged to something that is in the open spirit. But actually, I don't know whether there's any project, but I think that's very recommended.
I think you just have the isolated patent pools. We have one example later on, but I think there is no central register for this. One question Johannes asked in the chat: what is the financial framework for the costs of patents, utility models, etc.? We don't have the costs for utility models, but we have the costs for European patent later. I may have to correct me when I see the slide, but I think it's about 3,000 to 6,000 euros or so. It takes several months to be granted. But we have a slide on this later on, because when we talk about licensing, if patents make sense, or if it's not necessary to have a patent, and the strategic implications. Yeah. Felix, did you look up the term of protection for design rights?
I did. I can. So I know why we were confused about that. So it is indeed renewable, but there's a maximum term limit or a maximum duration limit for the lifetime of a design right. For example, a European design right is usually limited to 25 years, but you can renew it after every 5 years. I think after the initial 10-year period. Yeah, so it might differ from jurisdiction to jurisdiction, but usually that's how it goes. So there's a minimum and first initial phase, and then you renew it for certain increments of time. And those renewals are usually less cost intensive than the initial application. Yeah, so let's move further along with trademarks, I believe. Yeah, no, trade secrets, sorry. Okay, then trade secrets first. Trade secrets. So I think that's actually an IP right that most people have not heard of if you talk to non-lawyers, but it's actually an important one, at least for certain business models, I believe. You can think of trade secrets as the most versatile in terms of what you can protect with this IP right. And IP right, yes, it's an IP right, but it's not a registered one. So it's, yeah, I'll explain. So any information that is valuable and that is kept secret from others through certain protection measures. And the key part is that these protection efforts, these efforts to keeping the information secret, they must be provable or verifiable so that you can say, well, it's not just something that is kept hush-hush at our company, but we don't protect it, but we have certain measurements in place that we do in order to not get this information outside of our organization. And if you do that, actually you can protect any information that is valuable to you, which could include anything that might be protected by a patent, anything that could be protected by copyright, anything that could be protected by utility models or design rights. In essence, anything you can think of. And Fabian, correct me if I'm wrong on that one, but anything that you want to keep secret could be a valuable information that could be protected, but you need to enforce those protection measures. And the flip side to that is that you don't have an official title to some sort, like with a patent, where you have a document that certifies, well, this information is now belongs to XYZ, and it has this and this scope, and nobody else should use this because it should be a secret. And this in certain ways makes it flexible, so you can protect even things that might not be protectable through other IP rights. But another flip side to that, so two flip sides, is that trade secrets can be reverse engineered. So you can, if it's an independent discovery of the same information by a third party, then if it is independent indeed and not derived from secret information that you protected, then it's legal to use the trade secret, even if it's the same trade secret that you came up with in your manufacturing process, for example. And the risk of reverse engineering comes into play when you, for example, have a product where you did not, let's say, patent a certain mechanical component because you believe it's, well, very deep in your overall mechanical structure and your, let's say, robot. and nobody else will figure it out, but somebody might figure it out, might buy the product, might take it apart and reverse engineer your circuitry, for example, on your motherboard. And if they do that, that's actually, in essence, it's legal. So then you're not protected by the same scope of protection that a patent could grant you. There's no exception for others to reverse engineer a patent because you need to publish it. It is in the open domain then. Everybody can look it up, but they can't use it. It's different with trade secrets. If others get a hold of your trade secrets through means of independent discovery, like reverse engineering, then it's legal. If they, in any sort of way, perpetrate your security measures and obtain that trade secret by spying or for example, employing, well, that's actually a very difficult terrain, but let's say they pay somebody to give them their your trade secret, then that's also not legal. But reverse engineering independent discovery is legal, and that's a sort of a major risk, I would say, because sometimes from a practical, as a legal perspective, of course, needs to be independent, yes, but practically speaking, if somebody does the same thing and they can at least manufacture proof of how they came up independently with that discovery, that could be enough to circumvent your trade secret protection. And so
maybe one thing to add, since you were talking about patents, you may be wondering, okay, we are having a talk about open source hardware, so why do we talk about trade secrets at all? Because trade secrets are secret. But especially in conjunction with patents, trade secrets can make sense also in an open source hardware context, because in order to get a patent, you need to have novelty. And when you have lengthy development procedures and you put a lot of effort into developing an open source hardware product which you want to patent, then it's essential that everybody keeps the secret and maybe is obligated to do so, especially when you're working with a lot of people. On the other hand, when you yourself are leaving a commercial project because you want to make part of it or your ideas you contributed to it open source, then you have to be aware that there might be the possibility that they are saying you took our trade secrets with you and are trying to stop you that way. This is usually the case when employees leave a company and want to establish their own company, and they, for example, they are contacting old clients, etc. These are usually cases which are relevant. I did not hear from any of these cases in practice. I don't know if there's any open source project which uses trade secrets in part of the development process, but it could be an option.
Yeah, very, very valid point again. So even though it's, sorry, just one sentence and then, even though it's called trade secrets, it's not about trade in the narrowest sense. It's about valuable information. So you can think of it as some sort of a filler that you can use for information that you can't protect otherwise, or that is too sensitive to protect otherwise and publish in order to get protection, for example, for patents. And you can use this very flexible filler of trade secrets to be able to control your IP. And of course, you need to be aware of it. And that's probably also a major point. Yeah, Martin.
I think that was a good statement, because exactly this like legal filler material creates for people like me, which are not so deep into the scene, uncertainty basically. Mm-hmm. So I have a case that may not directly infringe patents, okay, but does it infringe any trade secrets or so? Yeah, but from the slide, it's very good to see that everything that can be reverse engineered is basically not protected by trade secrets, which is cool. So reverse engineering is, so at least in this domain, totally legal, including publishing what I found then, right?
Yeah, exactly. But it's important to note that it matters how you obtain the information. So you must reverse engineer it. If you take, for example, files with construction plans from your old company and then make them open source, that would violate the trade secrets possibly. And
Yeah,
I'd like to point out that this reverse engineering exception to trade secret law is relatively new. There's been a new European law, and since 2019, a new German law. So this is all an area which we lawyers don't know exactly how it's going to go in every case, because the law is new, and this is a very new exception. So where the line between reverse engineering and infringing a trade secret is needs to be seen, I think.
Yeah, where the limit of reverse engineering is specifically the question, because with enough effort, you may be able to reverse engineering just everything.
Yeah.
So from the last statement, so it could be that it is still illegal in the US, for example. So I shouldn't reverse engineer a MacBook.
Yeah, it could be, but I think the US first had this exception, and we took it and integrated in our law. I think I'm not sure on this. I would have to look it up, but I think they were first. But for example, in China, I don't know how this would go there.
I think they're pretty flexible about reverse engineering, but that's just a gut feeling. We have another question for this reverse engineering specifically, but I think we can do this later in the general discussion, because it also affects patent law.
Okay, yeah, great. We'll do that. In just shortly, so in addition to being this flexible material that you need to be aware of its, let's say, negative sides like reverse engineering, it has the upside of being not limited time-wise. So if you apply for a patent, that patent is limited, and after a certain time frame, it just vanishes in a way. It's available for everybody. That's not the case for trade secrets. You can protect them indefinitely. And I mean, its core nature is secret, keeping it secret, so it's an unregistered right. So as far as you, on the moment where you do those secrecy measures and you have that valuable information, it becomes protected. And this protection is on a national basis. So as Fabian said, it really depends on where you are, but there are some principles on how it usually applies. And if it is, at least if the country has some sort of regime on trade secrets, so we can make sense of trade secrets in a broader sense. But the details might vary, or might really vary from jurisdiction to jurisdiction. So it's different for example, patents. There's a treaty, an international treaty on that, and so it's much more uniform than with trade secrets. Yeah, it's so. Do I need to worry about utility? Sorry, there's a typo in the presentation. Should say trade secrets. About trade secrets, again, trade secrets, yes and no. So the problem with trade secrets, as Fabian already pointed out, is it's rather hard from a legal perspective to draw a bright line between what is allowed in, for example, reverse engineering and what is not allowed. So it gets murky, there's a gray area. And this also then applies to that there's a certain level of risk involved, because somebody might have this protected as a trade secret, but you might not know about it. But if that is the case and you did nothing wrong, then the risk usually is not that high, because you could potentially prove that you came up with the idea independently. So usually I would say, if you have not employed employees from other companies and they bring knowledge to your company and bring knowledge to your product, or you've obtained this information on your own from your employer or from a different company, then I would say the risk of trade secrets usually is rather low, at least in comparison to patents, in comparison to design rights and utility models. But if there are certain, let's say, certain activities that could be exposed to risk, like employees from different companies that are now working on your development of a product, then you should at least prepare them for what they can do and what they can't do, and you might have to check. But I would say, in general, the risk is rather low, especially if you have no further factors like employees from different companies with similar products, for example. And how do you apply for them? As stated, they are unregistered, so they arise naturally. You don't need to apply for them at a certain office. If you meet the criteria, then they are already protected. And trade secrets in the open source hardware context could be something like how you manufacture a certain hardware component, like your circuitry, or something different. But this, for example, could be protected by trade secrets, but as Fabian pointed out, it could also be a measurement that is taken in order to gain patent protection in the future, for example. So it's, as stated, it's very, very flexible. If you have valuable information, then this could be protected by trade secrets, and it might be worthwhile thinking about it if you have something that is can't be patented, but you want it to be, or that is not copyrightable, but you want it to be protected, then trade secrets are a good idea. Yeah, so I think now it's time for trademarks. Let's see whether it's time for trademarks. No, it's copyright. Okay, so, sorry. So trademarks is the last one. So I'm so enthusiastic about trademarks, but never mind. Okay, let's see what copyright can. Copyright actually, I think, is if you want like a highlight list of your most important IP rights for an open source hardware project, I would say it's patents, including utility models, and afterwards I'd say it's already copyright. Obviously it's on a case-by-case basis. So if individually your product is more geared towards optical appearance, a visual appearance, or you heavily rely on logos, for example, then trademarks or design rights might play a bigger role. But I would say generally patents and then copyright. And why is copyright so important? Because copyright, as we talked about before, protects an expression of an idea. So in order for a work to be copyrightable and be protected by copyright, it needs to be created in a sense. So as stated there in the second bullet points, it needs to be human-made, it needs to be observable. So for example, the idea of something, the idea of a documentation for your hardware, or the idea of how you would like to structure your circuitry, that is not protectable by copyright because it's not expressed as of now. And I think we have a minute to talk about the evolution of copyright here. So from a historic context, copyright is geared towards artistic work. So the painting, for example, is the prime expression of what should be copyrightable, and it is copyrightable. So the artist who's expressing his human approach to a certain emotional idea in a painting, that is the expressed work, the painting, the paint on the canvas actually, that's copyrightable and a creative work. And that, I think, encapsulates why some things fall under copyright and others might not. And yeah, question, of course.
I want to add, maybe you're aware of a very interesting case from, I think it was last year, the year before. Maybe you know the Brompton folding bike.
Yeah.
It had a patent which expired, and then the manufacturer in China copied it, and then Brompton managed to patent, actually to protect it under copyright. That was a quite interesting case there.
Yeah, indeed. Yeah, and that's actually a very good launch pad for another function of copyright. So copyright in itself is also very broad in its protection, or what you can protect. Because unlike, for example, patents or utility models, copyright is, as long as it is creative and it's expressed in a certain form, whether it's three-dimensional or two-dimensional, whether it's paint on a canvas, whether it's a digital image, whether it's a text that you write down, or whether it's a certain object you create, as long as it is creative and as long as it is expressed, then it is usually copyrightable. It might not have the same broad protection as more specialized IP rights like patents, but it is, at least against copies that are have only very, very minor alterations to what you already created, it is protected against that. And that is also the reason, I think in the Brompton case, the patent expired because patents are limited, right, after a certain amount of time. And afterwards, you usually need to think about how can I protect my invention further down the line and for years to come. And so it's usually not possible to, for example, take alterations to what you already patented in the past and just do something new with it, but not very, very different to what you already did before, and then apply for a patent and get it granted, because that's not novel and that's not an inventive step. But it might be enough to get it copyrighted. And that's what they went for. So you can think of copyright as another flexible IP matter, another filler. It's not as flexible as trade secrets, but it is flexible and can be applied to a lot of different subjects to get some sort of protection. But keep in mind, it's narrower in scope. It's really only intended to prohibit others from doing very similar copies to what is already expressed. Because if we remember that copyright is usually derived from this artistic, human-made artwork approach of the painting, copyright should not hinder others to iterate on your idea and to come up with other interpretations of what you already created. So the copyright regime should not hinder creative expression and creative development. And therefore, the threshold for infringement is much, much higher than in other IP rights, such as trademarks or patents. That doesn't mean that you can't protect some things, but it's the threshold is higher. And yeah, Martin, yeah.
That's an interesting point. So for music, there are sampling laws or something, so that I can remix a sample music that is allowed. Can I do the same with hardware documentation?
I think, yeah. So to be completely honest, the sampling thing with copyright is partly based on, let's say, core copyright. So the thing we talk about when you protect a sequence of music, for example, or a painting. And then there's another part that is still, it's in the copyright law book, let's say, but it's a different sort of right. It's more like commercial rights. So, and usually the sampling thing is I wanted to say the music is mostly playing in the second part, but that's a German expression for most important is the second part, which is based on let's say in German it's called Leistungsschutzrechte. That doesn't make sense to anybody who doesn't speak German, but those are rights that are linked to the commercial exploitation of certain rights, and those rights, they were created by you investing money into their creation, and that is different to how copyright functions. Copyright is granted because you invest artistic and creative freedom and your human approach to things into something, but it's not linked to money, to investment. And those other rights that are under the umbrella of copyright but really are, from a scholarly perspective, different rights. They are linked to the investment into that. So in your example of the sampling, it's the case that the investment into printing the CD on which the music is then saved, that actually is the link for those commercial rights. And usually when we're talking about sampling, we need to talk about the second pillar, these commercial rights, and they function a bit different to copyright. But
maybe
yeah.
one addition to understand this a little better, maybe, this is really a German perspective on copyright, because in Germany, a copyright is designed to protect the expression of the author himself or herself. So it's meant to protect the personality of the author that is part of the work that is protected. That is the reason why in German copyright law, you cannot trade your copyright. The copyright always sticks to the author. You only can license rights to use the copyright, and you can waive your right to be named as an author, but you cannot transfer the copyright to a company or another person. There is a special law for software, so that copyright in software are made in an employment relationship is the right of the employer, not the employee. But usually copyright is basically a personal right. I think you can say, but this is a very, very German perspective. I think in France, for example, you can transfer commercial rights, but not personal rights. I think in the US, you can transfer the whole copyright. So there are differences in what you can do with the copyright. And German law is a little tricky because we have these personality view on copyright.
And let me add that in the sampling example, it's European law, and this commercial part and your commercial investment into creating something, that's actually a European perspective on how copyright could work, or those special copyrights could work. And yeah, that's it. But coming back to your example, sorry for diving deeper into that legal doctrine. The question was whether you could, in a sense, sample a documentation, right?
Yeah, the issue specifically arises when I want to use documentations from different sources, which may have different licenses. Yeah. And then it was just a quick talk that I don't then need to respect all these licenses, but just take a sample of these and that and put them together. But I think if the sample is small enough, as to say, then copyright may just not apply.
Yeah. So let's say a rule of thumb. It's in indeed, if we look on a case-by-case basis, it might differ. But as a rule of thumb, if your text sample is small enough, it could qualify for not being protected by copyright. But there's something we need to address here, which is if your even short example of a text is creative enough. So if it's unique in a way, if it's only a text sample talking about how you connect A to B and blah, 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 then it might not be unique enough to be copyrightable. But if it's a paragraph about, well, our machine XYZ is the greatest and here's how it works, and only in 3 short sentences, that might be enough to be copyrightable. But those, let's say, day-to-day paragraphs that are just describing things could not fall under copyright. But let's be really clear here. I think you need to really prove or examine that on a case-by-case basis. But as a rule of thumb, yes, the shorter the paragraph becomes, the more likely it is that it's not falling under copyright protection.
And if I may add, short means really short. We're talking about, I think, like 50 signs or so, because to give you a more concrete example, Google used to you used to have a preview of press articles when you Google a topic, and they were sued massively by press companies and from copyright. So and I think they are not allowed to do this anymore, because even short excerpts and previews of printed articles infringe copyright of the authors. So my guess would be, I mean, Felix is right, you have to assess it on a case-by-case basis, but my guess would be that probably you wouldn't come very far trying to sample a documentation from several sources into another one. This would be my guess about it, but you would have to see.
Yeah, it's not that I would really try this. It's rather because sometimes people approach me in these legal questions, and sometimes they discover some sort of workaround or think they discovered something. So the main takeaway from this is just don't do that.
Yeah.
Don't try to work around licenses by sampling documentation. It doesn't really work.
Yeah, that's actually a great takeaway. But if they want to include the information, they can still rephrase it in their own words. So that could be a workaround as to how to get the information in. But sampling or just copying is usually not a great approach. Okay, can we go back just, I think I forgot something, or might have not, but okay, no, I didn't. Yeah, thanks, Fabian. We're one step ahead. So it's unregistered. You don't need to go to a copyright office or something, as long as you adhere to the work being creative, it being observable, and it being characterized by your approach to things. Then it is automatically protected by copyright, which is actually a huge strength to copyright. You don't need to do anything. It's automatic. Yes. And so we already touched upon, do I need to worry about copyright? As you can see, it arises naturally, and it has not the, let's say, steepest criteria for the steepest threshold for works being protected by copyright. So there's a huge amount of creative work that is protected by copyright, and even day-to-day works that are protected by copyright. So you need to be aware, if you copy something, as the word copyright says, if you copy something, or if you sample something from somewhere, that usually you run into the problem of that being protected by copyright, and that infringement occurs in the moment you copy that. And as there is such a huge body of copyrighted works, it is rather difficult to search for every infringement, even by the author. But also there's I would say, a whole industry just searching the web for copyright infringements of any type of work. So I would say do a basic screening, and if you copy something, if you are in doubt, don't do it. Rephrase it, do it yourself. But if you do it, check twice which licenses they have for using that content, if they have any. And if they don't, then probably don't do it, or ask and get written consent for using, for example, a certain documentation or using a certain image in the way you want to use it. That's basically what you need to worry about in copyright. So you need to worry about it, but usually you can, with keeping in mind not to copy anything without thinking twice about it, you can avoid the major pitfalls of copyright infringement. How do you apply? You don't, it arises naturally. And a good example, as Martin already pointed at, is a technical documentation, for example, a manual, or also for certain images, illustrations, logos. And in addition, but in Europe, that's a rather complicated thing. Sorry, no, we're not talking about it. So it's not a complicated thing, actually, for software code. So if you write software code, it can usually be protected, or is protected by copyright. It's not usually protected, or you can't usually protect it by patents. That's what I wanted to say. But copyright is the major source of protection for software code. And that's basically it for copyright, I'd say. And now trademarks. But trademarks, in a sense, I want to be honest, they are very helpful if you want to establish a certain brand, if you want to protect a certain image of your company, for example, and if you sell your products to others. But they do not protect, for example, technical components. They do not protect the mechanics of your work. So it's all about a visual appearance of certain elements, like logos, for example, or for example, your company name, or your product name. If you have a very creative name for a product that you want to protect, like Arduino, I would say that could be trademark protected, and then you can register it, and it is by far better protected than if you just had the copyright on the term Arduino. So trademarks, just to give you a bit of context, are specific signs, and they, as stated, function as a distinguisher for certain goods. So consumers see, for example, Nivea, or they see Microsoft, or they see Amazon, or they see Louis Vuitton, and then they associate this word or this logo with a certain manufacturer, and because of that, they buy certain goods and services of that enterprise, and they trust that what comes out of the factory of Louis Vuitton has a certain quality standard. So if the logo is on the bag, then that's what they want, and that's why they pay for it. And this is what trademarks should protect. So it's a distinguisher of origin to some extent. And for that to be able to occur with trademarks, they need to be distinctive. So you can't protect, let's say, I think there was somebody when the pandemic broke out who and everybody started to do online video calls. I think there was a mark for something that everybody, webinar or something, wasn't it, Fabian? Webinar? Yeah. I think
exactly.
Right? Webinar? Yeah, okay. I think somebody protected webinar. I don't know whether it's in every jurisdiction, but at least in the German jurisdiction, somebody had a trademark on the term webinar and protected it for virtual gatherings or something. And so now there was the confusion about whether anybody can use the term webinar when they invited people for something like this or a workshop online, or whether they would be liable to trademark infringement. But as the good side of the story goes, a webinar is not distinctive for a webinar because everybody calls it a webinar. And much like that, you can't protect, for example, video call for a video call. You could call it, I don't know, a dragon or something, which is not a substitute for the term video call. And then you could call your video call dragon, and you could get a trademark dragon for video calls. And then you have your video call software dragon, and that is protected because it's distinctive. You can distinguish that term from the commonly used term for the goods or services that you wanted to protect. In this case, a video call. So shampoo for selling shampoo is not a viable trademark, but Arduino for shampoo would be a viable trademark, because if you say Arduino, nobody would think, oh, that's a shampoo. Or at least not now. We don't know. Maybe they also sell shampoo in the future. And if that is the case, and your trademark is not confusingly similar to existing trademarks, you can protect it, and it is registered. And you can basically renew this protection, of this grant of protection, indefinitely. That is a great advantage of trademarks. And the scope of protection is rather broad, because anything that is confusingly similar to your protected trademark is infringing. You need to, in detail only for the goods and services that you claimed in your trademark protection grant, but confusingly similar and similar goods and services, and it's infringing. Okay, yeah, it's registered at your trademark office, and there's a public database where you can look that up. It's actually rather easy and intuitive to do that. So I would urge everybody who has a product name in mind that is not very obvious for the product they want to sell, or for your open source hardware product, to just look it up online, and maybe look it up in the relevant database. There is the database of the World Intellectual Property Organization, WIPO, WIPO.int, and they have a so-called brand database, the global brand database, and there you can just type in a term. For example, if you try with Nike, they should show you all the trademarks that contain Nike from Nike. And you can go about your own term in a similar way. So if you have, for example, Arduino, you could type in Arduino, and it shows anything that is to some extent similar to the term Arduino and is already registered. And there are multinational and national rights. So there's a European trademark, and there are national trademarks in the Netherlands, in Benelux, in the USA, all around the world. There are national trademarks, and there are certain multinationals. Yeah, next slide. Thank you. Yeah, it's interesting that the term "do I need to worry about" is always the one from the slide I already did. So it should say trademark, not copyright in this. Should you worry about it? I would say yes, even though it's not something that protects your mechanical engineering, for example. You should check for the names you're using in connection with your product, because there's a very large and sophisticated infrastructure for companies to apply for trademarks, but also to enforce and discover infringements of their trademarks. So it's rather likely that if you're using a term prominently that is already protected by a trademark, that you will be discovered and there will be some repercussions for it. So there might be a cease and desist letter from a lawyer, or you might need to pay a licensing fee, or they might just want you to not use it for certain kinds of uses. So I would always urge you to check online, see whether the term is used, and also check in the relevant registers at your local or multinational office. And also it might be beneficial to just shortly check in with a trademark lawyer, for example, or somebody who knows trademark law to get you because sometimes it's not that obvious. If you have a term that is like Arduino, but Arduino, the trademark is registered for, let's say, software, broadly for software as goods and services, and now you want to use Arduino for a motherboard, then it could be beneficial to ask a lawyer whether the protection for software could also encapsulate the protection for your motherboard that you want to use it for. It's not that obvious from time to time, but you can check first yourself, and then in cases you're not sure about, you can ask an expert. And yes, yeah.
I think there's also an example where we can learn a bit from open source software. For example, LibreOffice is being hosted by the Berlin-based Document Foundation, and they had taken some measures to protect their brand and their trademark.
Yeah, thank you. Yeah, for sure. So I think in the open source and open source hardware space, trademarks are used from time to time, as you pointed out, and they do not hinder the open source approach, I'd say. So it's because it's on a different level. So you're not trying to exclude others from using the technical innovation, for example, that you want to have the others able to iterate upon, but you want to protect your organization from others that are trying to free ride on your established reputation, for example. And it's rather easy and cost efficient and cheap to get trademarks. We are in comparison to patents, it's a fraction. So we are talking about, I would say, a couple of hundred euros for protection on a national level, and even sometimes on a European level. And so it's a cheap alternative, but it grants rather good rights and a rather good sense of security, at least to the names you're using, and could be beneficial, yeah, or for the logo.
Maybe two additions to the trademark issue. The first is with regard to, you said that they don't hinder the open source idea. In fact, there are so-called warranty marks you can use to establish a certain standard. For example, bio is one for nutrition and for foodstuffs. So if you want to market your food as bio food, you have to comply with a certain standard and take certain measures to locally farm it, don't use pesticides, etc., herbicides, and then you can use the term bio because it's registered as a warranty mark. I think I would have to check, but it's some example. In the same way, you could use an open source hardware logo for every project that complies with the DIN spec for documentation, for example. So people can see at first glance that this has a certain quality, this project, and they can be sure, for example, it can be rebuilt or something like that. Yeah, Martin.
Yeah, we had this discussion actually with Dean about about a trademark for a DIN-SPEC certificate. Who, for those who don't know, DIN-SPEC 3105 is a standard stating the criteria for technical documentation to be open source hardware to qualify for that. So because the OSH definition is a little ambiguous about that, and DIN-SPEC then states which things do you need to publish, so that that a few PDFs don't suffice. You also need like the source files of things and in a editable format and stuff like that. So it also describes how to review this hardware and how to attest that something is really open source according to those requirements. However, from the standard itself, from the standardization perspective, this must be free. So we cannot enforce a trademark for DIN-SPEC 3105 certification, because this must be available for every party. Otherwise, other people would need to ask us if they can do and conduct the certification. But however, if you do that, you could still trademark your certification scheme. Yeah.
So basically, people who want to certify their documentation, they can use it. But what do you do if you have somebody who uses this trademark but that doesn't have proper certification? I mean, people would find out because they're trying to rebuild, and then they would know that they can't because it's not up to the standard. So you would have to enforce it against such projects, right?
Mm-hmm. Yeah, so there's basically no protection. Everybody can self-certify themselves. That's totally legit. But you couldn't say this hardware has been attested or assessed according to DIN-SPEC 3105 by Open Source Ecology Germany, because we didn't do that.
Mm-hmm.
You could state that you did it yourself, for example.
Mm-hmm, mm-hmm. Yeah. I mean, that's one way to do it. And another aspect I wanted to mention about trademarks is Felix initially said that the chances that you are caught when you are using a name that is similar to a registered trademark is very high. And I think this is very true, because I would like to point out that a trademark owner has disadvantages in his protection if he tolerates other similar trademarks in the area it's protected for. This is called dilution. So as a trademark owner, you really have to make sure that there are no other trademarks for the goods or services you protect. You have your trademark registered for, because then other people would say there are a lot of similar trademarks. The scope of protection becomes very small. So they all have an interest in keeping a greater scope of protection, and therefore enforcing their trademarks. At least companies, the commercial companies, were using trademarks in a non-open source way.
Yeah, I think that's basically it for the building blocks of IP rights that you can use and how they apply. And Fabian will now take this to another level with licensing and how you use it practically with defensive publishing. So if there are there any questions regarding this or any other IP rights? Yeah, Martin.
I have a slightly irrelevant question regarding copyrights, but I don't know how our schedule is. That's something totally optional from my side, and it's not really connected to open source hardware.
Fabian, I think you can decide.
Yeah, just ask. I mean,
okay.
Okay.
We can briefly get to it.
Okay.
We had this discussion in our community. So if I have a creative AI algorithm that creates paintings, or there's one that creates piano pieces that others cannot distinguish from human-made pieces, who owns the creative work? The one that hit the button for the algorithm, or the algorithm itself, or is it public domain?
That's a a great question that closely relies with my PhD thesis. There's also a nice dissertation on that. No, but yes, that's actually a rather complicated question, to be honest. I would say rule of thumb, at the moment, it's the one who is, or usually it's the one who's pressing the button and who's initiating the process, and usually also setting parameters. And in the end, they usually also select the works that are viable and discard the ones produced by the AI, which are not. But there are certain examples which are tailored towards being, let's say, exactly in that gray area, and maybe turn it up by 100. And they want to achieve that it's only the AI and not a human who's the right owner. For example, I don't remember, but there was I think an artistic one which created certain paintings or so, but it was not the ones that you know, like the Bellamy thing and the different Dutch painter AI and so on. But if you can configure an AI in a way that it, first of all, self-executes, and that it self-evaluates and discards all the pictures that it doesn't want you to see. So in a way, it's a self-propelling loop, or there are minimal input from a human. For example, start with, I give you a certain amount set of pictures, and then you create whatever you want with it. If that is the case, at the moment, I and probably a lot of other researchers would say that's already in the territory of an AI inventor. And if it is an AI, an AI artist, let's say, because it's concerned with copyright and not patent law. If it's an AI artist who created those works, then it's not protected at all, because under, at least under German copyright law, but also usually under copyright laws around the world and in Europe especially, but there are certain examples, for example, in South Africa, and there was a case in China where they granted copyright protection to a software in sense. But it's usually not the case. Those are outliers. Then it's not protected because copyright law, as Fabian also explained, is based on the artist, the human artist, and the artist's personality reflecting in the work. And therefore, it can only be a human who obtains copyright, which is, yeah, we can talk about whether that's right or not, but that's usually the case for artistic works in the classical sense, at least. And therefore, it's not protected. So anything an AI produces at the moment that is so self-sustained and so detached from a human that you can't consider it being made by the coder, for example, or the one who executes the function of the AI, then it's not protected. It's public domain, actually. You can do whatever you want with it.
And to add two points to this, there's a similar discussion with regard to animal-made artistic works. There was an American case with a monkey who took selfies from himself, but I think the courts decided that there was no copyright protection because it was a monkey who used the camera. I wonder, last week I read about a painting elephant. I wonder if it would be different in that case, because the elephant uses the brush to make the pieces of art. And there's also a similar discussion in patent law. Felix briefly touched upon this, whether you can register an AI as an inventor. And I think there's one African patent office who allowed it, but there are others who didn't. So it's really changing area of law, and we don't know yet how it will unfold in the future. Welcome back. So do you have any questions from the break? Anything related to the IP rights block you want to know? Okay, that doesn't seem to be the case. Now I'm going to talk a little about open source hardware rights management, which in the essence, in my opinion, is licensing, because you need to have an overview of how to administer the rights. You saw that it might be really complicated because there are so many rights can be at play. They all have to be or might not have to be managed in a way. So I'm just going to give you a basic overview of how licensing works, what licenses are there, what types of licenses are there, and maybe you can, in the end, we can discuss if you want to have a deep dive workshop into licensing. I have some topics prepared, which I could touch upon in that, but now I'm going to give you a basic overview here. So what is a license? Felix initially mentioned that traditionally IP rights prevent you from copying a technology, an artistic work, etc., using a trade secret, using a trademark. So a license is a permission to do, use, or own something, in this case, an IP right. It's a permission to use copyrighted material, a permission to recreate or rebuild a patented technology, etc. So why do we need licenses? It's first to be able to use IP protected material in case you want to use a project which is open source. You probably need a license. You may all know this from open source software. Without a license and adhering to the licensing conditions, you cannot use it. I will in a minute explain why licensing software is so much easier and less complicated than licensing open source hardware. And the second important reason why do we need licenses is because licenses from an administrator point of view can help keep open source hardware open, because if you want your project to stay open, if you don't just want to get it out, but if you want that it stays open for everybody, you might need to use a special license to achieve that goal. What kind of rights can I license? There's an important differentiation I want to make. It's about, on the one side, emergent rights, I call this, so rights that arise automatically, like copyright, like trade secrets can be an example. On the other hand, we have rights that are not automatic, that are registered or negotiated. So you have, for example, patents, you have trademarks, you have designs, and you have contractual rights. So what the difference is in licensing these different rights, I'm going to explain in a minute. But there are some important differences when licensing these kind of rights. One important point for the importance of licensing from the area of open source software, and I think this is comparable. There has been a case in the US, I think it's in 2009, at least the headline is, where Cisco used firmware in their routers, which was partly open source software. So, but they did not adhere to the licensing conditions. So basically they had no license for this. They were sued by the Free and Open Source Software Foundation, and they settled this in the end for, I think the amount they settled for is not known, but they made, I think they should have made a sizable donation to the foundation. And this is one example for why this is so serious, this issue, and you have to adhere to the licensing conditions. And it's the other case, it's more recent. The report is from 2020. This concerns software used in airplanes to show films on the airplane. And there too, this software was at least partly open source. I think it was Panasonic who didn't comply with the licensing conditions in this case, and they were sued because they didn't. And this headline illustrates that it was literally a 100 million court case. So there's a real financial risk if licensing conditions are not met. On the one hand, this is good news because if you have an open source hardware license and some commercial actor is trying to free ride on this, you have a real threat for them to make their material open source, their contribution open source. So to make it more difficult to free ride. On the other hand, it's a risk if you take material, you should always check, is this open source? What is my source on this? But I guess that you would do this anyway. So this is just to illustrate how big these cases can be. One note that is important in this is that these are American cases, and in America you have much higher damages in these court cases than you would probably have in Germany. I'm just seeing a question from Leopold. He asked, why is open source software easier for licensing? And points out that there's a jungle of more than 300 open source software licenses and only a few serious open source hardware licenses. So what's the problem? From my perspective, the problem is that open source software licenses rely on copyright. So it's easier because you have automatically a right you can license. When you are dealing with hardware and you don't have any copyright, I'm going to go into detail on this in a little more in a minute. But when you don't have an automatic right, for example, and you need a patent, for example, then you have to create a right first. So you have already, in case of open source software, you already have a right you can license. In case of hardware, you may need to create one. I hope this answers the question. And Martin has a comment too.
Yeah, regarding what is actually protected by a copyright license in the case of hardware, as far as I understood, I can license the documentation and maybe bits of the design of the actual machine. But when someone chooses to copy the machine, so let's say someone takes my design files and then alters a little bit the design and publishes and then sells the machine, but doesn't contribute back to the documentation. From my perspective, this would still be legal in case of a copyleft license because you didn't do any modification to the documentation itself. You just read it and used it for constructing something else. So the copyleft license is what, or what the one OSH lawyer put it that way, that copyleft licenses are a hint for good actors, but not really a threat for bad actors in the case of hardware.
I totally share this view because you're absolutely right. When you just have a copyright license for documentation and you have a product which is easy to rebuild, and people don't change the documentation but simply build the product in another way and distribute it, etc., then if you don't have a patent or something you can license, it's much more difficult to enforce or to bring people to contribute back. What you can do is you can create a contractual right for this. So you can say that people who are using the license for the documentation, you include a clause for people who build the product that they need to contribute back, for example. But this would be a contractual right that binds only the people who take the license. So if by some way people don't take the license or give it to third actors who are bad actors, then you have and the chain of licenses is not complete. It's easier to break it because it's only binding to the contracting parties, really. So this is what I meant when I said open source hardware licensing is more complicated and it less easy than software licensing. Now Leopold is saying that in open source software there are also millions of users and only few contributors. I don't know how to respond to that, basically, because yes, it can be true, but I don't see any issue with this. Martin, Felix, do you see any issues?
No, not. Maybe Leopold, do you want to specify what you mean by this comment? What the question is?
Yeah, I just understood that that's your argument. Why it is one of the arguments why it is easier in open source software. And
because it's more widely used. Yeah, maybe the case. The protection issue was also from Warrants for the RubRub. So there was a post in their wiki that they protected the design, the documentation, or whatever would fall under copyright by GPL 2. I think it was GPL version 2. And yet you find a lot of derivatives of the original RubRub printer that don't even mention that they have been derived from RubRub, because the functionality itself was not patent protected or so.
That's a good example. That's basically what we I think that's a point we mentioned earlier, that you can build the product. So you can't control the downstream use any further. So when you have a 3D printer and only the documentation is licensed under copyright, people can look at it. They can build the 3D printer. They can develop it. They can develop it further and make it. It might even be possible to patent it if they have something new, and then lock out the other good actors. That could be a problem too, because you can stop them from building the physical artifact when you don't have any right that prevents them from doing so.
Okay, I understand the problem, but that might also happen with software. There are a lot of big companies taking over open source software and make a strange fork, and then you have the same problem.
Yeah, that is a problem, but as the cases I just mentioned illustrate, if you have a foundation like the Free Software Foundation, they can attack this use, and they have a copyright. So they can say, you can't use our software unless you contribute back, or unless you adhere to our licensing conditions, which is only fair, basically, because they have these, they have the right, and they have the license, and everybody can use it as long as they observe the license. In case of hardware, you don't even have the means to do that in some cases. So you have to take more care, I think, at looking what is protected and what do you want to have protected.
Okay.
Now I have another question of how about reverse engineering of non-open source hardware products, like rebuilding, cloning a commercial product and then selling it or publishing it as open source hardware. Can you specify what you mean, or give an example? Because it's important to know, what are we talking about? Copyright? Are we talking about a patented product?
Yeah, I don't know. Can you hear me well?
Yeah.
Yeah. There was like the question in the chat group, basically, but like someone started mainly for educational purposes to reverse engineer like amplifiers or something that are not on the market anymore, and to rebuild them, the KiCad files and so on, and then publish this. So one question probably is like trademark or something. Do you mention the name of the original product, but just if you just copy the hardware design of something, is this already problematic, or is it only patent law that you might be infringing?
I mean, Felix, correct me if I'm wrong. I think it could be problematic if you widely distribute it. If you use the logo of even if it's older and if it's if it hasn't been used in or apparently hasn't been used in a couple of years, this might already be trademark rights might be an issue. Patent can surely be an issue. But also copyright. I think you can have problems in many areas of IP because I mean there is an exemption for these rights for private use, usually in general. But I think for educative purposes, there's no exception. Felix, what do you think?
Yeah, if I may add on that, so I think it all depends on whether they have protected so the case is you have something that is no longer produced, for example, and somebody reverse engineered that mechanical part, let's say, and is now distributing it and referring to the original, how the original part was called. I reversed engineered and now you can buy XYZ mechanical part. And if that is the case, I think there's a huge differentiation between whether the old manufacturer, the old inventor and producer has, for example, patented that mechanical part. If that is the case, and the patent is still valid because it expires after some amount of time, if it is indeed still protected, then you can't reverse engineer it and be able to distribute it because there's no such exception for patent law. That's only for trade secrets. If the patent is no longer valid because it expired as well in the past and now it's not patent protected anymore, you could reverse engineer it and you could potentially even sell this mechanical part. There might be some exceptions to that, case-by-case basis, you need to look at it, but usually that could be the case and now you can use it. However, on the trademark side, first of all, if the old manufacturer has some sort of logo and some sort of brand name that he associated with this product used and has a trademark registered for that, and now you are selling a reverse engineered exact copy basically of the discontinued mechanical part, then I would say trademark is an issue if the trademark is not expired and is still valid, because on the trademark there's one exception that could apply in this case, but I believe it won't apply in this case if you just reverse engineer it and sell it as is, as a continuation of the older product. And that would be that you are allowed to use the name of a product and use logos of a manufacturer if you are selling the original parts, for example, on a secondary market. For example, example would be cars. If you are somebody who buys used cars and sells them on, then you can use the logos of the manufacturer, for example. Or if you are, for that car, producing accessories, for example, or different parts that are not the car itself, but for example, the wheel. Then you can also, to promote your own product and say, well, it is compatible with BMW, you can use the logo and trademarks of BMW to refer to it. But as far as I understand, that's not the case. Martin, I saw you, sorry, I just wanted to finish that train of thought. But as far as I understood, that's not the case here because it's not spare parts for a mechanical product that already existed and was produced by the original manufacturer, but you would actually replicate the discontinued product and build it yourself and then sell it. And there I would say the trademark does not apply. But if the original manufacturer has not protected by trademark or by patent law, there's a good chance that with a certain level or time-wise, a certain period between discontinuation and now you're starting your production and selling it onwards, then you could legally do it, but that depends on a few factors. But I think that these are the two cases. Martin.
I agree with Martin first.
Yeah, this last one reminded me of a statement of yours that you would never get a yes, that's safe from a lawyer.
Yeah, that's probably really true. I'm sorry.
Oh yes, that's safe to say, Martin. But in this case, actually, it depends on, because I don't know the exact circumstances of how that product is produced on and sold onwards.
And I think what's important is that if it's trademark protected, that you don't create the impression of being the original manufacturer. Yeah. This is what Felix said. If you say it's compatible with, or this is a recreated original spare part from, then it's probably you can do it, but you can't say I am Mercedes, for example, or create the impression that you are, or the unofficial manufacturer or something like this.
Mm-hmm. Yeah, what I wanted to say was actually just said by you two. So if I say it's compatible with, then I'm not infringing the trademark because I'm not preventing to be Miele if I distribute like the main switch of my washing machine. What?
I think it's an echo.
Okay, okay. But related to this, we had a larger discussion in our chats, and that was especially exactly around this reverse engineering of electronic goods. So if I take the example of a washing machine and the main control switch, which often breaks, then I assume that there is some sort of protection around this, which is not just trademark, but maybe patent. But from my personal perspective, this would be too minor for patent protection, but okay, who knows? There may be some sort of protection, and the washing machine is not so old yet, maybe like 5 years or so. And it broke, and now I reverse engineered the PCB behind the control switch. And I have the design files even digital on my computer as I reverse engineered them. Am I allowed to publish them? So others could put them for themselves for private use.
That's, as you already noticed, as it depends. First of all, again, if it is protected by something other than, I would say, well, let's say trade secrets, but if it is protected by, for example, a design right, which could be, I don't know how major that part is, or a patent, I don't know how mechanical that part is, then you probably can't do that. I think it's in a gray area because you are trying to use the exception for private use, which is applicable not for all IP rights. So it would, again, depend on the IP right that grants the protection. But it could be a way of doing that. But, well, on a case, really, that one is a case-by-case basis. We would need to look at which IP right and how long is that protection already granted for, and how is your license, for example, wrote out so that you just allow private use in very limited circumstances.
But I think generally, if you publish it and make it publicly available, then it's probably not private use anymore. So private use is usually, for example, in copyright, to have like 3 copies.
May I add one before we do the okay, before the 2 questions. In addition, there's one thing that could allow you to do that for repair of consumer goods, nowadays, because there is a concerted effort by the European Union and also in some national jurisdictions to forge a framework, a law framework to allow repair of certain mechanical, certain electronics, certain consumer goods in the end to take place. And I believe there are some exceptions for exactly that cause to allow replications to be for private use, but I don't know, maybe it's also commercial use to repair consumer goods. But there's a very limited list of goods that this applies to at the moment. I think it's something like washing machines and refrigerators at the moment.
And do you know, is it in force already or is it forthcoming? Because
no, for the refrigerators
yeah.
and so on, there are some exceptions that are actually in force at the moment. But for the broader category of goods, it's not in force yet. And for the design rights perspective, so the Autofägen, I don't know how to say that actually, the wheels, that is in force, but it won't apply, I think, in the same way as Martin would like it to. For
okay. And FVM, sorry to keep you waiting. You have a comment.
No problem. We didn't want to break the communication. Going into the could be louder. Am I understandable?
It could be a bit louder, but
could be a little louder, yeah.
So maybe yes, maybe no.
Yeah.
So, if there are some, let's call electronic principles which are in a patent, under patent, and how often do these principles need to be published in repair manuals or in wissenschaftlichen Arbeiten?
Yeah.
Until that's getting common knowledge and therefore public good and public usable.
So as far as I know, just once. If you publish something one time, it becomes state of the art. The important aspect is that the patent examiners can find it. So you have to publish it in a way that I mean that they read scientific publications, for example. There are also online solutions which collect state of the art technical publications to make it available to patent examiners. So it becomes state of the art. I will elaborate on this more when coming to how to defend open source hardware. Maybe let's get back to the licensing part, because I'm a little worried that we don't finish our program in time. But it's very interesting to discuss this with you, because we only have the legal perspective, and as you may have noticed, we don't know really much about the practical aspects of developing mechanical aesthetic products, etc. So it's very helpful for us to get your questions and your views on this. Coming back to the licensing, we have the traditional licensing scheme, that's IP right. So I have the exclusive right to use, modify, and distribute copyrighted material, for example. Then we have free and open source licensing that says basically everybody can use, modify, and redistribute. And this goes into the direction of permissive licenses, which I'll explain in a minute. And then we have IP left, or at least that's what I tend to call it. It means that everybody can use, modify, and redistribute something, but it includes copies and modifications. So if you want to distribute these, then you have to make them available under the same license. So there's a chain of licenses, and the goal is to make every fork and every everything you modify available under the same license again. So the open source, the material that is open source gets bigger and bigger. Basically, that's the idea behind it. But I'm sure you are familiar with this. So coming to the different licensing flavors we have in open source hardware, which are relevant. First, we have permissive licenses, for example, CC BY 4.0 or CERN OHLP. And I want to emphasize here what Leopold already said, that there are only a few licenses which are really suited for or intended for hardware. That is, for example, the CERN OHLP. The CC BY licenses are intended for copyright. So they are basically targeted at artistic works, texts, or software. And it's difficult, if not impossible, to use them for hardware too. But these are examples for permissive licenses too. So they say everybody can use, modify, and redistribute. You don't have any IP left, and downstream proprietary use is allowed too. So the idea is basically you get your idea out, and you don't care what people do with it. You wanna have your idea free, and you don't take care of downstream use or modifications being also free. So they can be closed afterwards. Then we have weak IP left effects, for example, in the CERN OHL-W. And also it's interesting that the CERN OHL is the only license I know that does this distinction between weak IP left and strong IP left. So they say you have an IP left, but it only changes to the licensed material itself must be licensed downstream. So you have something that is licensed. If you use it and modify it, you must make your modifications available under the same license too. On the other hand, you have strong IP left, for example, the CERN OHLS and the GPL3 could also be counted in this, I think. It says that possibly, and the scope depends on a case-by-case basis, you have to make all material you use available and license it downstream. So what I mean by this is, the question is when you are designing, for example, a 3D printer, what parts of it do you have to make accessible? Only the core parts like the design, or do you have to license every screw and every bar of metal that is used for this? This is something addressed, for example, by the CERN OHLS. This is just to give you an impression of that you have many options for licensing, and you have to decide what you want to achieve with your project, in order to decide on the license. This is just a very brief overview. We would have to go into more deep detail with regard to the single licenses to explain them a little more, but I hope this clarifies that there's not a one-way solution to do this. Also, a very general overview, what you have to do is licensee, sorry, it says licensor. You have to retain existing notices to license material. You have to name the original author. You have to add a modification notice saying that you modified the original. You have to make the license text available. This is what applied in the Cisco case, I think, that they didn't make the license text available. And if necessary, you have to relicense, or you have to license your modifications under the same license, the IP left. So this is basically, in a nutshell, what the most important obligations you have to observe. Once again, the differences between open source hardware licensing and open source software licensing. In open source software licensing, I'm starting on the right, you have software which is automatically closed because you have an automatic copyright on this. So you have to license it in order to make it and make it open. So you have legal material you can work with. In case of open source hardware, it's a little more complicated because you can also have software, and you can have documentation, which we already talked about, which could be protected by copyright. So it's basically the same as an open source software, but you have hardware, which is, as long as you don't have any patent or design rights, free. So you have to take, if you want to license a right, then you have to create a patent, for example, or an utility right, or you have to create a contractual rights in order to really license this. The downsides of patent and contracts compared to copyright, which is automatic, there for Johannes, we have the costs for filing a patent at the EPO, so the European Patent Office. It's about 6,000 euros official fees. And I think in practice, it's a lot more expensive because I had the impression that it's difficult to draft a patent and that you should use a patent attorney for this and for support. So the costs are add to the 6,000 euros. So I think filing a patent can easily cost more than 10,000 euros in that area. And it's also a lengthy procedure. So it takes 3 to 5 years to get a European patent. And I think it's similar for other patent offices. In addition, but this is no different from copyright, you have litigation costs. So in order to enforce a license, in order to enforce a patent, you would have costs for litigation for the lawyer who takes care of this. With regard to contracts, they basically don't cost anything, but as I already mentioned, they are binding only for the contracting parties. So if you have a bad actor in your chain of licenses, and Martin already said this, licenses are great for good actors, but they don't protect as well against bad actors. Because if you have one and he gives the license material to a third party who is not bound by the contract, then you don't have any right you can enforce, basically. So there is a gap of protection, I would say, with regard to open source hardware licenses. Leopold asks, so since hardware is free per default and there is no patent on it, why do I need an open source hardware license anyway? I think it depends on your perspective. If you are a user, you basically don't need a license, so you can just use the technology, you can just build something, but and this works as long as there are only good actors. But if you are a developer of open source hardware and you want to make sure that downstream your technology stays open and people share their modifications the same way you shared your initial material, then you would need an open source hardware license to make sure. So it's a system that would technically work if everybody would observe the open source hardware principles. But in case you have a bad actor who applies for a patent, for example, then you have the risk of closing off an invention, for example. Does it answer your question?
Not totally. I understand the argument with the modification.
Yeah,
but it cannot be patented. If it is published, it's not new, so you cannot make a patent out of it.
Yeah, you cannot publish. You cannot publish the initial material, but when you have people contributing and somebody makes an inventive step with a contribution which is itself patented, then he can get a patent on that contribution and close at least this part off.
Okay.
So this is the argument. So you're right. All that you already have published can't be patented. That's true.
So it could destroy this open source state when there is no license on it.
Yeah,
Okay.
That is a risk. That is a risk I see when you don't have any license.
Okay, thank you.
Yeah, you're welcome. Then I have another question. But if someone patents something you published, wouldn't their patent application? Yeah, exactly. That's the case. That's called defensive publishing. And it's already a good way to protect against patent trolls, for example, because they can't patent anymore. Okay, now I'm going to briefly touch upon strategic implications, but we have another question. It says, if I want to prevent others from patenting their additions to what I've published, can that only be achieved through, in your words, IP left licenses instead of permissive licenses? I think that understanding is correct, because when you have a permissive license, everybody can do anything and is not obligated to share their modifications, for example. If you have an IP left effect, they are at least contractually bound to share the modifications in the same way. Martin, you look skeptical.
Yeah, no, that's all right. I was just reflecting on these words. What the open source hardware license is then for, if I can use it without, of course, modifications, and I can add more rights or more limitations, or let's say like a list of rules how my material is to be used. But I could even fork the whole documentation and no, okay. No, just random thoughts. It's not yet a question or something. Yeah.
It's okay. Robert, do you have another question? Can you clarify a little? Because Robert asked why. So
yeah, sorry. So I didn't get the question in the first place. I mean, if I it's an interesting one. It's the first time I hear about it. If I publish patent something, sorry, if I publish something and then someone makes an addition and wants to patent that addition, why would it be prevented by a copyleft license? That part I didn't get.
In my opinion, it is because an IP left license would require the downstream user to share their modifications and publish them under the same license, and not to get a patent. So you have a contractual right that you can enforce if it comes down to it. So the initial question was basically, why do I need an IP license at all? Because hardware is free anyway. In my opinion, it is about establishing a certain control over modifications and downstream use, and ensure that these modifications are added to the open source hardware material. So to not, because as I said at the beginning, the great potential of open source hardware from my point of view is that you can have a pool of knowledge that gets bigger and bigger with each contribution. And I mean, you can take the approach that you say, I want to publish what I have, and I don't care if downstream users share their modifications and contributions. But then the initial material won't get any better, I think, and it wouldn't take advantage of the of others who contribute to this. Is that clear?
It's the first time I hear of it, but I understand the logic completely what you're saying. I'm just curious now, because I have not heard of any cases where this has been violated, and in a way I would not assume that many people know this actually. So, but anyway, food for thought. Let's see what happens.
I think for open source hardware, this whole licensing topic is relatively new, and I don't know any practical case either. I always compare it to the free and open source software cases, where you saw that it's a real issue. And I mean, you could have a commercial actor like Cisco or a Panasonic or etc. Take open source hardware and integrate it into their products and take advantage of a community who puts a lot of effort into developing this open source hardware, and then just use it for free and neither pay any royalties nor having to share share what they do with it.
Exactly. Yeah.
So
yeah, it's a good. Yeah. Sorry.
This is I think the point why a license could be beneficial.
Hmm. Yeah, it's the first time that I hear a good argument also for copyleft licenses, but I don't want to drag this conversation on actually, because generally I would have otherwise lobbied for permissive licenses in most cases when people ask me what to use.
Yeah. I mean, I think it depends on the approach you take. But this is just to give you an overview. So to go on in the presentation, you have a lot of strategic implications in deciding what is the right license. So the first question is, what is my design, and what Felix already told us, which rights apply to it? Do I have a mechanical design? Do I have an artistic design? Do I have copyright? Do I have patents, trademarks, etc.? Then important question, and this is what Simon asked before the workshop, is how do I take care of the interests of people who invested money in developing open source products and invested time in it? So the question also is, what is the business model? Is it selling the product itself? Is it selling related services? And when I sell services, for example, then I might not need, then a permissive license might suffice. When I'm selling the product itself, I might have to get a patent. I might have to use a patent license. With complex products, which cannot be easily rebuilt, it might suffice to only license the documentation, because without documentation, people cannot build it and not get a patent. But this is really flexible and depends on a case-by-case basis. Also, it's important to know what is the competitive edge. So is it the technology itself? Then I would have to get a patent again. Or is it the personal know-how of the people working on this project? So then maybe I don't need a license at all. A permissive license is okay. Because I can depend on the people which are on the project as long as they stay. Is it the image of my company, for example, Arduino? Then I can get a trademark or a warranty mark and license it to others. Or is it lead time? So maybe it's enough to do like version lagging, as Martin mentioned earlier with the premium version. So the most current version is premium and it's not for free, you have to pay for it, but other versions or versions that have not the same abilities can be licensed open source. Another comment on a separate note, I find the term reciprocal licenses to be more intuitively understood. I think a reciprocal license, as a lawyer, I would intuitively think about cross-licensing rights and not strictly on IP left. And I think, Martin Felix, correct me if I'm wrong, that this copyleft, IP left, and permissive are already established terms with regard to licensing. Thanks very much for your comment. We have another comment from Johannes. that said, if you institute a patent litigation against an entity, including a cross-claim or counterclaim in a lawsuit, alleging that the covered source or a product constitutes direct or contributory patent infringement, or you seek any declaration that a patent licensed to you under this license is invalid or unenforceable, then any rights granted to you under this license shall terminate as of the date such process is initiated. Do you have any question or comment with this?
No, that was just from the license, the part which is about the patent law.
Yeah, exactly.
I think that's applicable, and the downstream problem with the patents.
Of course, it's a very good example for an IP peace provision that says you cannot patent anything and you cannot attack somebody when you're taking the license. But I'm going to this also in a moment when we're talking about defending open source. With regard to the strategic implications, I also wanted to mention that it's important to think about what you want to do with the design. So just make it accessible, or control the downstream use. And if you want to make use parts of it or the whole project commercial or non-profit. But this already goes away from making it open source. Then finally, the question, what should I license? So the design, documentation, or the software, and all or just part of it. And of course, which format and where to license. So where do you put it? Do you put it on Thingiverse? Do you put it on Git? There are multiple options. Johannes, yes.
Yeah, another question for the strategy.
A very good point. I think with regard to the licenses itself, it should not be a big problem because they are available for free and you can just use them. You have to maybe observe that when you have to administer the license, so you have to monitor the use of the license, etc. That can be costly, and when you need some rights, for example, a patent. That should be calculated as well. Does this answer your question, Johannes?
Yes, for the moment, but I think that's a great problem for the community. Mm-hmm. The funding to get a lawyer funded. Every decision here with patents and every law problem is a money problem.
Yeah. Martin, do you want to comment?
I want to point out that for specifically these issues, the organization Open Source Ecology Germany exists because that's also how the guideline for legal issues was born. So we collected legal issues in the community, and then we still have that connection to one of the biggest law firms worldwide that have a pro bono department. So their lawyers are obligated by their working contracts to contribute 35 to 100 hours per year, depends where they work and which country, to pro bono projects. So we could gather some of these questions, and when they appear to be from public interest or non-profit interest, then we can have them solved for free, if there are any concerns.
If I may add on that point, because I think, Johannes, from what I gathered, your question was also in the direction of what can I do now without much funding, and what maybe is too expensive and I should do later, if at all. And I think there are certain parts that can be done without any money needed or any external help, but without any substantial money that needs to be put up upfront. And these are usually the ones we are presenting in the category of know which rights are there and try to assure yourself through researching in the relevant databases whether there are any others who already possess trademarks, who already possess patents, who already have a license, and now you can understand how this license might work and whether that's applicable to your product. So these are kind of do-it-yourself things that don't require much funding. There's, of course, as always with do-it-yourself, there's an amount of risk that you can't control if you're not an expert in that field. But it's for free, basically. You can look up trademarks, you can look up patents, you can look up the license. And after that, there's, I think, a block which is, if you do it yourself or do it with minimal help, it's still rather cheap in comparison to what you gain in protection. And these are usually the rights like trademarks. Also, if you have something that is copyrighted because it arises automatically, getting a open source license that applies to your needs. They are free themselves, so you can usually use them, and you can license certain parts of your product yourself. So trademarks, the licenses, and for example, a utility model is also a cheaper option to a patent. And after that, there's a block which I completely agree with you. If you want more certainty in the realms of trademark protection or copyright protection or utility models, or if you want to go for a broader right which covers more of your core mechanical invention like a patent, you probably need either expertise in that field to do that properly and not throw the money out the window or get something that you don't really need in the end, or you need an expert on that, and that usually costs money. But I think on that part, if you're still in the phase of starting up and starting your journey on this open product, I think, as Martin said, there are certain organizations like the open source hardware from Martin that can help you with that. There are also, from my experience, if you look at the EU IPO side, there's also a European fund for startups that can apply for funding for trademarks, for example, or for design rights and patents. So that might also help you. So there are certain mechanics that can be in place for this early stage if you want to go a bit further down the rights. But I think there are 3 blocks. So it's for free, but do it yourself. And it's mainly being aware of risks that already exist without you gaining more protection per se. And then there's the gaining some protection, but for a limited amount of money. And then there's the gaining broader protection, but it costs a bit more money. And you can spend in each bucket or not spend in some buckets, and you can get help for the others. At least that's my perspective as of now. So feel free if there's anything to add.
And I'd like to add that that is one thing we want to do with our research project, that we want to see where the issues are, because often this is basically, legally speaking, so new, this whole open source hardware development, that we don't even know the specific legal issues, because there are basically no court cases on this. So what we are trying to do is we're trying to assist in developing some solutions, some best practices, what to do, and maybe make you aware also with this workshop here of what are the risks and what you should maybe avoid. And we are happy to go into detail on this in further workshops if you have specific questions, because I think it has become clear by now that this is, legally speaking, a really complicated issue, because there are so many rights at play and so many interests, and also so many ways to do open source hardware and to be active and participate in this in so many perspectives. So this is just a basic overview. but we are in the way of developing some guidance on this and how to do this. Going on with the licensing part. So this is basically a wrap up of what I just mentioned. What are the do's in open source hardware licensing? Take care of the attribution, make it transparent. So see that you upload all necessary parts of the project, the license itself, and I would recommend to complete licensing, to license all of the project, except if you have special needs. For example, financially speaking, make the license and design available. This is very important. And if you use other material for your project, check if there is any open source hardware licenses or open source software license on it. This is particularly important because some licenses are not compatible with others. So then you will have to see what if you have to relicense something you used. And check the licensing scheme. For example, is it by SA? I like to point out that NC and ND, so non-commercial and no derivatives, as I said at the beginning, are not open source hardware. But I just included them to make it complete. So you have to think about what kind of license you wanna use. So in the interest of time, I would just go on into the defending open source hardware topic, just briefly, except if there's any pressing concern, question, etc. From any of you. Okay, that doesn't seem to be the case. So how to defend open source hardware, how to keep it open. This is just a preliminary overview again over the issues. First, I'd like to briefly touch upon the risk of patent lock-in. So we already talked about it basically. The problem that can arise is you have a downstream user who acquires own rights. For example, who makes a modification that itself is patented, or which is what is copyrighted and doesn't share it, and then says you can't use any of the material you licensed before, at least as part of a threat. Even if it has no substance, it can be a problem for open source hardware projects. The second problem are non-practicing entities, so patent trolls. If they have acquired a lot of patents, they can try to extract royalties from good actors like open source hardware users, just by threatening with patent litigation, which is very costly. And this brings me to the next point. The risk is always IP infringement litigation. So what do you do, or how do you protect yourself against a third party coming to you and saying, you use my invention, my copyrighted material, my design, etc. You have to pay me royalties. And as I said, even if it has no substance, because you don't, you would have to, for example, you would have to get a lawyer to defend yourself, which costs, and even if you are reimbursed, then you have to advance the costs. So even the threat of IP infringement litigation can be enough to stop a project from happening, basically, I think. So what can you do against this? The first we have already talked about is basically defensive publishing. So to establish, as Leopold shared, sort of an open patent office where you basically publish all the informations on an invention to destroy novelty. So as Felix said, patents require novelty. The goal is to destroy this, so the material can't be patented anymore. The challenges here are that you have to sufficiently and broadly disclose your informations. You have to invest, I think, a little in the planning, time and money in it to do this. And you have to secure access to patent examiners. I have one example here that's for defensive publishing platforms that exist. It's tdcommons.org, and I think it's a platform where also bigger companies participate to share some inventions. I have another question here that says, can we create a open source hardware body that collects patents and protects against claims by big industry? Martin, are you aware of any projects who do this already or are going to?
So can you repeat? I just made a screenshot of the slide and added it to a document that I was creating.
The question is, can we create an open source hardware body that collects patents and protects against claims by big industry? And I think it would be similar to the Free and Open Software Foundation.
Yes, you could do that. When I was writing this book chapter in OpenX, I was searching for a practical case of patent left. So where someone applied a copyleft license on a patent, and I found something in biotechnology that was mentioned, but not a very hard reference yet, just like in a publication. And as far as I understood the case, but that's also some time ago that I read it, they tried to buy patents and then put a copyleft license on that. I know that this is happening in some domains, but I'm moving into a gray area of my knowledge, so not quite sure who's doing that and to which extent, because it is costly, of course.
Yeah. I too think that it could be done, but I don't know anybody that does it. By the way, small correction. I was just reminded that it's Free Software Foundation and not Free and Open Software Foundation. My apologies. Then the next thing you can do is IP pledges. What are IP pledges? They are basically unilateral promises. They say that the IP owner will not enforce rights. An example I found, more recent example was a COVID-19 IP pledge, for example, from the University of Oxford, or a little older, an IP pledge from Tesla that said they won't enforce their patents. I think they did it because they wanted their technology to spread. And it is a way to say, to encourage communities to use a certain technology. The challenges I see here are that there are uncertainties regarding scope, enforceability, and reliability. So as these pledges, to my knowledge, have never been tested in any court, it's unclear how reliable they are. So the question is, can somebody who makes an IP pledge just take it back and then sue for patent infringement, for example? I would think not, but there are uncertainties and risks associated with it. Then we have open IP agreements. Martin, you just mentioned it. The basis are bi or multilateral agreements. So the goal is to make oneself immune to infringement suits, for example, by collecting patents. And how this is done is by cross-licensing. So the members of these agreements cross-license their patents to each other, so they have a right to use. And when, for example, a patent troll comes from the outside and says, you are using my patent, they can say, no, I don't. And for your information, I have the rights to use these 30 patents who all relate to the same invention or to a similar invention. And then you can sue me for infringement. So this is what I mentioned also before, is to pool IP rights to make oneself immune against threats from the outside. The challenges here that I see are administration costs, and that the effects are limited to the members of the community. So if the community is big enough, that's great. But if you have only like 3 participants, then the protection is not that big. The forms this can take, as far as I know, are, for example, IP peace provisions. That's what Johannes posted a little while earlier. So the promise not to attack each other and not to patent licensed material. Then we have defensive IP licensing that says you can use my patents and vice versa. And other network effects. For example, there is the Linux Open Innovation Network where Linux related knowledge is shared, and also other IP pooling measures. Thank you, Robert, for participating.
Yeah, thank you also. So yeah, really enjoyed it.
And this was
have to leave. Bye bye.
Yeah, bye. This was basically it from my point. So now we have almost reached the time limit, but if you like, I am available. I think Felix too for a little discussion. We could possibly talk about future topics. So if there's something that is very interesting for you, for example, a deep dive into licensing, a deep dive to trademarks, trade secrets, etc., or in particular, as promised for licensing, if you want to know how to do it in practice, best practice examples, what relicensing means, multi-licensing, license compatibility, or version lagging, we could do separate workshops on this, or separate units on these things. It really depends on what is most interesting for you. I hope that this presentation gave you a little overview over the legal issues and how complicated it can be. Yes, and I hope you enjoyed it. We have a high-level question here. The word right is used a lot today. Is there a legal definition for what a right is versus other things? This is very deep. I think we could fill many more hours with this. So a right, I think the short answer, a right is the permission, the exclusive permission to do something. This is maybe this in a nutshell. Felix, do you have any addition to this?
Actually, I don't, because I think that under German law, there's a legal definition of a right, but it only pertains to civil law. And there's a huge discussion about the origins of rights, where they arise from, whether they are natural rights or given by the state. So I would also leave it at something that grants you at least a permission to do something. But usually I think rights are constructs that allow you to exclude uses of certain things.
At least when we're talking about IP rights.
Yeah, a question, I think.
Or comment.
Is one more topic to be taken on the last slide. Is the big elephant of certification. Certify the open source hardware. How do you get CE signs for products with open source hardware and so on?
Yeah, that's great that you mentioned it. We are aware that this is a very big issue. We did not mention this in this presentation because we are mostly focusing on IP rights per se, but we have someone in our research group who does research on the certification of open source hardware products and projects. So we can take this up and see if we can organize like a basic workshop for this, an introduction into certification. It might take a little because I don't know how far along they are with this particular research project, but I will definitely ask in our research group if somebody's available.
Great, thank you.
Yeah, I take the word now. So I would encourage an applause round, but it's very difficult to do this online. Thank you very much for the input.